ಸೇವ್ ಮಾಡಬೇಕು ಅನ್ನೋದು Mm. Mm-hmm. കോർട്ടുകൾ കണ്ടോ വിൻസെന്റ്? കോർട്ടുകൾ വേണേ പാത്തു മൊത്തം ക്ലിയർ ആയി. വിൻസെന്റ് വന്ന് ആയിക്കോട്ടെ. ഇങ്ങനത്തെ ജഡ്ജുക്കാർ വന്നിട്ടില്ല. 5 മിനിറ്റ് ഉണ്ട്.
ಹಲೋ, ಹೇಳಿ. ಹೌದು, ಅದಿಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿದ್ರಂತ ಕಾಣಿಸ್ತದೆ, ಬಟ್ ಅದ್ರಲ್ಲಿ ನಂಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ. ಆ ಫೈಲ್ ಅಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ. ಅದ್-
is urgency. ಯಾವ ಇಯರ್ ಫೈಲ್ ಮಾಡಿದ್ದು? ಯಾವ ಇಯರ್? 22. ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಆಸ್ ಪರ್ ರೋಸ್ಟರ್. ಹಾ ಯಾವ ಇಯರ್ ಅಪೀಲ್? 21. ಹಾ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆಗೋವರೆಗೂ ಕಾಯ್ತಾ ಇದ್ರಾ? ಆಯ್ತು, ಕೊಡ್ತು ಆಸ್ ಪರ್ ರೋಸ್ಟರ್. ಕೊಡಿ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ, ಮೆಮೋನು ಕೊಡಿ ನೋಡೋಣ. ಇಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಮಂಡೇ ಅಂತ ಹೇಳಿ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಮಂಡೇ ತಗೊಳ್ಳಿ, ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ. ಟ್ರೈನ್ ಟು ಯಾವ ವರ್ಷ ಫೈಲ್ ಮಾಡ್ರಿ ನೀವು ಅಪೀಲ್ ಯಾವ ವರ್ಷ ಫೈಲ್ ಮಾಡಿದ್ರಿ? 2018. ಈಗ ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ? 4 ವರ್ಷದ ಮೇಲೆ ಕೊಡಿ ಬರ್ಲಿ. ಸೀನಿಯರ್ಸ್ ಮೇಲೆ ಹಾಕ್ಸಿ ಮೇಡಮ್, ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಹಾಕ್ಸಿ. 55. ಒಂದು ನಿಮಿಷ, ಪೇಜ್ ವೈಸ್ ಕರಿತೀವಿ, ವೇಟ್ ಮಾಡಿ. to 20. 18 ಹೇಳಿ. ಅಭಿಜಿತ್ HM. ಲಾಸ್ಟ್ ವೆಕೇಶನ್ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೆ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ. ನೋ ಡೇಟ್. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು 25? ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇನೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಪ್ರೇಸ್ ಟೈಮ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ವಾಸ್ ಹಾಸ್ಪಿಟಲೈಸ್ಡ್ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಸ್ ಫಾದರ ಮತ್ತೇನು ಆ ರೀತಿ ಹೇಳಿದ್ರು, ಅದೇ ರೀತಿ ಬರ್ದಿದ್ರು ಡೇಟ್. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಇಲ್ಲ. ಇದಿನ್ನು ಇದಾಗಿಲ್ಲ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಫಾದರ್ ಈಗ ರಿಕವರಿ ಆಗಿದಾರ? ಮತ್ತೆ ಆಕ್ಟಿವ್. ಇದು ಏನೋ ಡಿಸ್ಮಿಸ್ಡ್ ಓನರ್ ಟು ಏನೋ ಓವಿಂಗ್ ಟು ದಿ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಮಾಡ್ಬಿಡಿ, ಯಾಕೆ ಮತ್ತೆ ಹಾಕಿದ್ರು? ಏನಿದೆ, ನಾನು ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್. ಅವ್ರು ಇನ್ನೊಬ್ರು ಯಾರೋ ಕೇಳಿದ್ರಲ್ಲ ಮತ್ತೆ ಟೈಮ್, ಇನ್ನೊಬ್ರು ನಿಮ್ಮಂಗೇನ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂತ. ಆಯ್ತು ಕೊಡಿ, ಅದನ್ನು ಕೊಡಿ, ಇದು ಕೊಡಿ. ಅದ್ಯಾವ್ದು ಹೇಳಿ ಇನ್ನೊಂದು? 18. ಇನ್ನು ಕೊಡಿ, ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಜಾಸ್ತಿ ಇದೆ ಇವತ್ತು ಅಡ್ಮಿಷನ್ಸ್. 2nd of February ಡೇಟ್ಸ್ ಇದೆಯಾ? ಟೈಮ್ ಇದೆಯಾ ಮೇಡಮ್? ಇದೆಯಾ? 2 of February. ನಿಮ್ದು ರೀ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೇಸ್ ಟೈಮ್. ಪ್ರೇಸ್ ಟೈಮ್ ಡಿಕ್ರೀಡ್ ಕನ್ಫರ್ಮ್ಡ್. ಇನ್ನೇನಿದೆ ಇಂಜೆಕ್ಷನ್ಸ್. ಆಯ್ತು ಕೊಡಿ, ಕೇಳಿದವ್ರಿಗೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ. 2 weeks. 3rd ನೆನ್ನೆ ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟವಲ್ಲ ಮೇಡಮ್ ನಾವು. ಸೆಕೆಂಡ್ ಈಗ 6 ಕೊಡ್ಬೇಕು. 6th of February. 48 ವೆಯ್ಟ್ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ಸೀರಿಯಲ್ ವೈಸ್ ಕರಿತೀವಿ, ಪೇಜ್ ವೈಸ್ ಕರಿತೀವಿ. ಪೇಜ್ ವೈಸ್ ಕರೀಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನಾನು ಪೇಜ್ ಎಲ್ಲ ಹುಡ್ಕಾಡ್ಬೇಕು. ಅದಕ್ಕೆ 28 to 35. 28 to 35 ಯಾರು ಇಲ್ಲ. 36 to 42. 37 ಹೇಳಿ. ಏನಯ್ಯದು? ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೇಸ್ ಟೈಮ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ನಾಟ್ ವೆಲ್. ತಗೊಳ್ಳಿ, ಅದನ್ನ ಒಂದು ಬರ್ಕೋಬೇಡಿ. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಹಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ ಆರ್ಡರ್ 41/27 ಅಂಡ್ ಸೇಮ್ ಇಸ್ ನಾಟ್ ಪುಟ್ ಅಪ್. ಅದರ್ ಸೈಡ್ ಯಾರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? ದೇವಾನಂದ್ ಮಾಡಿದೀರಾ? ಮಾಡ್ಬೇಕು. ನೀವು ಕೋಟಾಲಿಂದ ಹೊರಗೋದ ತಕ್ಷಣ ಮರ್ತೋಗ್ಬಿಡುತ್ತೆ ಇದು. And hence registry is directed to put up the application, and council also undertakes to inform the other side council, and hence this matter on 6th of February. Intimate ಮಾಡಿ ಈಗಲೇನೆ. 43 ಇಲ್ಲ, ಇನ್ನು 42 ನಲ್ಲಿ ಇದೆ. 43 to 49. ಹೇಳಿ ಯಾವ್ದ್ರಲ್ಲಿ? ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೇ ನಿಮ್ಮ ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ ಇಲ್ವಾ? ಯಾರು ಇಲ್ಲ. ಕೇತನ್ ಕುಮಾರ್ ಗೊತ್ತು ಬಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕು. ಆಯ್ತು ಆಯ್ತು. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಅಂಡ್ ಆಲ್ಸೋ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಇನ್ಫಾರ್ಮ್ R2 ಕೌನ್ಸಿಲ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಅನ್ ಯಾವಾಗ ಬೇಕು ಕೊಡಿ, ಯಾವ್ದು ಕೊಡಿ ಮೇಡಮ್. 6-2 44 ಹೇಳಿ. ಪಿ ನಟರಾಜ್ ನೀವ್ಯಾರಿಗೆ? ಮಹೇಶ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ. ಹಾ ಅದರ್ ಸೈಡ್ ಮಾಡಿದಿರಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಿಕ್ಸ್ R1 ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ಇಲಾಖೆ 2-3 ಹೆಸರು ಇದೆಯಲ್ಲ. ಪಿ ಮಹೇಶ ಫಾರ್ KVR ಅಂತಿದೆ. CR ರಾಜಶೇಖರಪ್ಪ ಫಾರ್ R1 ಅಂತಿದೆ. ಆಯ್ತು, ನೀವ್ಯಾರಿಗೆ ಹೇಳಿ? KVR ಪಿ ಮಹೇಶ್ ಅವ್ರಗ. ಮತ್ತೆ ಇಲ್ಲಿ DR ರಾಜಶೇಖರಪ್ಪ ಇದಾರಲ್ಲ. ಕನ್ಫ್ಯೂಷನ್ ಏನು ಮೋಸ್ಟ್ಲಿ ವಕಾಲತ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ. ಆಯ್ತು R1 ಕೌನ್ಸಿಲ್ ಹಿಂಗ ಹಾಕ್ಬಿಟ್ಟಿದೆ. KVR ಕೌನ್ಸಿಲ್ ಪಿ ಮಹೇಶ್ 6 ಟೈಮ್ and also submits that he has already informed appellant counsel and hence this matter on 6-2. serial number ಹಾ ನೀವು ಯಾರಿಗೆ? appellant ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ? ಹೇಳಿದಿರಿ. appellant counsel 6 ಟೈಮ್ and also submit that he has already informed respondent counsel and hence this matter on 6-2. ಎಲ್ಲ ಕೇಳಿರಂಗ್ರಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಅಟ್ಲೀಸ್ಟ್ ದಿನಕ್ಕೆ ಒಂದಾರು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡೋಣ ಅಂದ್ರೆ ಯಾರು ಬರೋದೇ ಇಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ಗೆ. ಅದಕ್ಕೆ ಅಡ್ಮಿಷನ್ ಅಲ್ಲೇ ಟೈಟ್ ಆಗಿ ಇಟ್ಕೊಂಡ್ಬಿಡೋದು. CH ಅವಿನ್ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಬಂದಿದೆ. ಆಯ್ತು, BS ನಾಗರಾಜ್ ಅವ್ರಿಗೆ ಹೇಳಿದೀರಾ? The counsel CH ಅವಿನ್ appearing for respondent submits that he has filed wakalat ಯಾವಾಗ? Today in the office and hence the office is directed to put up the wakalat. Also counsel undertakes to inform appellant counsel. This matter on 6-2. 50 to 52. ಯಾವ್ದು ಹೇಳಿ? 52 ಸಂಗಮೇಶ್ವರ್ ಹೇಳಿ. ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
I appear for the respondent, my lord.
ವೈಕೆನ್ ಶರ್ಮಾ.
ಅದರಲ್ಲಿ of course today's adjournment I have no objection, but matter is urgent ಹಾಗೆ ಆಗಿದ್ದು. If it is to be first week 7th ಏನಾದ್ರು ಹಾಕೊಳ್ಳಿ, if it is convenient to the court. Date may be fixed. 2 ಸಲ ಆಯ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿತ್ತು.
6th ಆಗೋದಿಲ್ವಾ?
6th ಇಲ್ಲ, ನಾನು ಇರೋದಿಲ್ಲ. 7th ಆಗ್ಬೋದು.
ಆಯ್ತು 7-2 ತೊಳಿ. appellant counsel 6 ಟೈಮ್ and respondent counsel also present and request for posting of the matter on 7-2 and hence post the matter on 7-2. The registry is directed to delete the name of Mohan Chandra P. Intena ideyalla madam. Ivrel since with counsel Sri Vaiken Sharma has filed wakalat with NOC.
One more submission, my lord. ಅದರಲ್ಲಿ ನೋಟ್ ಇದೆ, there is a writ petition copy produce ಮಾಡಬೇಕು ಅಂತ. It is already produced and marked as exhibit D22. already mark ಆಗಿದೆ ಅದು D22 ಅಂತ.
ಆಲ್ರೆಡಿ ಇದೆಯಾ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ?
D22 exhibit D22 writ petition order.
ಆಯ್ತು, ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ರೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್
apply.
At 2:30 madam. No submission. No submission. The presence of other side you make any submission. Madam 2:30 state council ಬಂದಾಗ submission ಮಾಡಿ. Clarification ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ ಅವ್ರು ಇದ್ದಾಗ ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲೇ ಮಾಡೋಣ. not in the absence of other side council. ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಇದೆ. ಆಯ್ತು, ಆಮೇಲೆ ನಂಬರ್ 3 ಫಸ್ಟ್ ಕರ್ಸಿ. ಬೇರೆ ಕೊಡ್ತು ಇದೆ ಅಲ್ಲ? ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಒಂದ್ ನಿಮಿಷ, ಒಂದು ಎಲ್ಲ ಕರ್ಸ್ಬಿಡ್ತೀನಿ, ಇರೋದ ಮಾಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಸತೀಶ್ ಜಿ ರಾಯ್ಕರ್. ಏನ್ರಿ ಇದು? ನೋಡಿದ್ದೀರಾ ಮೇಡಮ್ ಇದು ಸರ್ವ್ ಆಗಿದೆ ಅಂತ? ಇಂಟಿಮೇಷನ್ ಡೆಲಿವರ್ಡ್ ಕ್ಲೈಮ್ ಇದೆ. ಇಂಟಿಮೇಷನ್ ಡೆಲಿವರಿ ಆಗಿದ್ದು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಹೆಲ್ತ್ ಸಫಿಶಿಯಂಟ್ ಮಾಡ್ತೀನಿ. ಬಟ್ ಅಬ್ಸೆಂಟ್ ಇದೆ. ಇಂಟಿಮೇಷನ್ ನಾಟ್ ಡೆಲಿವರ್ಡ್. ಇಂಟಿಮೇಷನ್ ಡೆಲಿವರಿ ಆಗದವ್ರು ಹೆಂಗ್ ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಎರಡು ಸರಿ ಹೋಗಿದ್ವಿ, ನಾಟ್ ಫೌಂಡ್ ಅಂತಷ್ಟೇ. ಅಲ್ಲಿಗೆ ಇಂಟಿಮೇಷನ್ ನಾಟ್ ಡೆಲಿವರ್ಡ್ ಅಂತ ಆಯ್ತು. ಆಬ್ಸೆಂಟ್ ಇದೆ ಅಲ್ರಿ? ಇಂಟಿಮೇಶನ್ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಬರ್ದಾರಲ್ಲ ಅದ್ರಲ್ಲೇನೆ ಅಬ್ಸೆಂಟ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಯಾರಿಗದು ಎಲ್ಲರಿಗೂನ ಎ ಅಂಡ್ ಇ ಅಂತಿದೆ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಅಗೇನ್ಸ್ಟ್ ಪ್ರಪೋಸ್ಡ್ R2 A and E returned with the postal shara as unclaimed and on perusal of the postal cover intimation was delivered and in spite of it not claimed and hence held sufficient against R2 A and E. ಅಷ್ಟೇ ಅಲ್ಲ 2014 ಮಾತ್ರ ಏನಕ್ಕೆ ಬರ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಏನಕ್ಕೆ ಬರ್ಬೇಕು ಬ್ರಿಂಗಿಂಗ್ LRs of deceased R2 on record ಅಂತ ಇದೆಯಲ್ಲ ನೆಕ್ಸ್ಟ್ ಅಗರ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಡಿ ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ IA ನಂಬರ್ 4 of 22 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಆಯ್ತು ಎಂಟ್ರಿ ಏನು ಹಾಕಿದಾರ ಎಂಟ್ರಿ ಮಾಡ್ರ ಈಗ ಇದೆಯಾ ಇಲ್ವಾ ಅಂಡರ್ಟೇಕಿಂಗ್ ಯಾವಾಗ ಇದ್ದಿದ್ದು ಆಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆಯಾ ಪಿರಿಯಾಡಿಕಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಅಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಮೇಡಮ್ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರ ಇದೆಯಾ ಸೀಕ್ವೆಂಟ್ ಆಗಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆಯಾ ಇಲ್ಲ ಇಲ್ವಾ ಎಕ್ಸ್ಟೆಂಡ್ ಯಾವಾಗ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ರೀ ಅದು ಆರ್ಡರ್ ಡೇಟ್ ಯಾವಾಗ ಯಾವ ಡೇಟ್ ಹೇಳ್ರಿ ಆರ್ಡರ್ ಜನವರಿ ಆಗಿದೆ ಅಂತ ನೋಡಿ ಮೇಡಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಡಿ ಕ್ಲಾಸ್ ಪೋಸ್ಟಿಂಗ್ 4 January 23 ಅನ್ನ ನೋಡಿ ಕ್ಲಾಸ್ ಪೋಸ್ಟಿಂಗ್ ಅದೇನಾ ಇದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಂದ್ರೆ ದೇ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗಿಲ್ಲ ಇಲ್ವಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಇದಾರ ಆಯ್ತ್ರಿ ಹಿಂದೆ ಆಗಿದ್ದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರನೇ ದ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ ಇಸ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡರ್ however learned counsel for the respondent while seriously objecting the same would submit that his clients will not precipitate the matter for 15 days ಅಂತ ಅವರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ 15 days ಗೆ ಈಗಿಲ್ವಲ್ಲ ಮತ್ತೆ ಅವರು ನಿಮ್ಮ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅನ್ ಒಂದ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ 24 ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅನ್ 24 ಅಂತ ಮಾಡಿದ್ದೀನಿ ಏನು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಏನು ಈಗಿರೋದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಾಕಿದಲ್ಲ ಇದಾರ ಯಾರು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಸತೀಶ್ ಕುಮಾರ್ ವಿಜಯ್ ಕುಮಾರ್ ಇಲ್ಲ ಬೋತ್ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಆಬ್ಸೆಂಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್ ಆ ಕೊಟ್ಟಲ್ಲ ಯಾವ್ದಾರು ಕೊಡಿ ಅಂತ ಹೇಳಿಲ್ಲ ಯಾವ್ದಾರು ವೀಕ್ ಆಫ್ಟರ್ ಕೊಟ್ಬಿಡಿ 2007 ಸ್ವಲ್ಪ ಅರ್ಲಿ ಡೇಟ್ ಕೊಡಿ 30th ಲಿಂಗಮೂರ್ತಿ ಯಾವಾಗ ಬೇಕು 2007 ಮ್ಯಾಟರ್ ಎನಿ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ 30th you are for respondent or appellant? Appellant counsel present this matter on 30th. This counsel.
So the respondent counsel informed us today that they asked us to granted on the 2nd.
No, you are representing appellant. Appellant counsel present list this matter on 2nd of February. In VR, V Anand. Both the councils are absent. List this matter on 2nd of February. Narayana Bhatt, Nataraj Ballard. Both the councils are urgent. Dismiss matter on 2nd of Mayor. S.V. Prakash. Both the councils are urgent. Dismiss matter on 3rd of February. PB kept bill on ಇದೆ. List 3 ಇದು ಪೃಥ್ವಿ ಒಡೆಯರ S.V. Prakash ರೆಸ್ಪಾಂಡೆಂಟ್ PB kept bill ಅಂತಿದೆ ಹೋಗಿ ತಗೊಳ್ಳಿ ಅಲ್ಲಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಪೇಪರ್ ಬುಕ್ ಇದೆ 3rd of February serial number 2 ಅಲ್ಲ list number 2 Bhaskara R. Appellant counsel is absent and appeal was filed in the year 2020 till date. Office objections are not complied and even in spite of matters listed for second time before the court for non-compliance, no representation and hence the ends of justice on cost of ₹1,000 payable at registry, 2 weeks time granted to comply with office objection. And if office objections are not complied and cost not paid, this matter for dismissal on 6/2. Mallappa PM, A. Nagarajappa, same order. Council, the appellant council seeks 2 weeks time. Bakidella same madam on cost of ₹1,000. 2 ವಾರ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್. ನೆಕ್ಸ್ಟ್ ಕಾಸ್ಟ್ 1,000 ಪೇಬಲ್ ಅಟ್ ರಿಜಿಸ್ಟ್ರಿ ಕಟ್ಟಿ ಹೋಗಿ. 3rd time ಹರೀಶ್ ಭಂಡಾರಿ ಟಿ. Appellant counsel seeks 1 week time. Same in Bakidella Aston. Appeal was filed in 2020 and the matter is listed 3rd time for non-compliance. And on cost of ₹1,500 payable at registry. This matter on 6/2 if not complied and not paid the cost. Next. Mohan Chandra P. ನೋಡಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ಸ್ ಎಲ್ಲ ನೋಡಿ ಮೇಡಮ್. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫಸ್ಟ್ ರೈಸ್ ಆಗಿದ್ದೆ ಅವಾಗ ಡೈರೆಕ್ಟ್ ಕೋರ್ಟಿಗೆ ಬಂದಿತ್ತು, ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಬಂದಿತ್ತು. ಅವಾಗ ಏನಾಯ್ತು?
Office objection in regard to maintainability is overruled ಅಂತ ಆಗಿದೆ.
ಓವರ್ರೂಲ್ಡ್ ಆಯ್ತು. ಅದು ದಟ್ ಈಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಓನ್ಲಿ ಮೇಂಟೈನಬಿಲಿಟಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ರೂಲ್ಡ್. ರಿಗಾರ್ಡಿಂಗ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್, when the matter was called initially, the learned counsel for the appellant submitted that all the office objections are already complied with 25/11 ನಲ್ಲಿ. On verification, the office reported that none of the office objections are complied yet. When the matter was called for the second time, learned counsel for the appellant is absent. There is no representation. I do not find any reasons to adjourn the matter. However, to afford a final opportunity, list this matter on 19/1/23 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಅಂತಂದ್ರೆ ಹೆಂಗ್ ನೋಡ, ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದಲ್ದಲೆ ಕೋರ್ಟ್ ಮುಂದೆ ನೀವೇ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೈಂಟ್ ವಿತ್ ಆಲ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ. ಅಡ್ಮಿಷನ್ ಬಂದಿಲ್ಲ, ರಿಗಾರ್ಡಿಂಗ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಬಂದಿತ್ತು. ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಹೌದಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ. ಕೊಡೋದು ಹೋಗ್ಲಿರಿ, ನೀವು ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಹೇಳಿ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ 25/11ಕ್ಕೆ. ಯಾವ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ. ಮಾಡಿ ನೋಡಿ. ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ submits that he has not been given an opportunity to comply with office objections and the said submission cannot be accepted for the reason that the appellant counsel himself made the submission before the court on 25/11/2022 that he has already complied all the office objections, and this court passed an order on the same day that on verification the office reported that none of the office objections are complied yet. And also in the second time when the matter was called, appellant counsel was absent. However, this court has observed that no reasons to adjourn the matter with an intention to afford final opportunity, time was given, and in spite of it, office objections not complied. But counsel submits that file was not given to comply with, and the said submission cannot be accepted. However, in the interest of justice, another 1 week time granted to comply with office objections and cost of rupees 1,500 payable at registry. This matter is if office objections not complied and cost not paid, list this matter for dismissal on 6/2. Number 5. Dismissal order kodi. ಬೆಳಗ್ಗೆ ಇದೆ. So date ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್, ಒಂದು ಫಾರ್ಮಲ್ ಇದಿದೆ ನೋಡಿ. 23/10/21. This court granted 2 weeks time to comply with office objections, failing which this matter for dismissal, even in spite of 2 weeks time granted on 23/10/21, even after the 14 months, the office objections not complied, and hence appeal is dismissed for non-compliance of office objections. Non-compliance of office objections. It is same as madam 25/10/21. In spite of 2 weeks, 14 months, complied, dismissed. R. Kotwal. Madam, must 27/21. 3 weeks time granted. In spite of 14 months, not complied, dismissed. 26/10/21. 2 weeks time granted. In spite of it, 14 months not complied, dismissed. Vinod Reddy. 27/10/21. 3 weeks time was granted. In spite of it, even lapse of 14 months, office objections not complied, and hence dismissed as ordered earlier. Upesha. Same madam, 26/10/21. 2 weeks. Chandrakant Tariga. ಯಾವಾಗ ನೀಡ್ಫುಲ್ ಡನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ? ಟುಡೇ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ್ ನೋಡಿ ಮೇಡಮ್? ಅಲ್ಲ ರೀ, ನಿಮಗೆ 2 weeks ಟೈಮ್ ಕೊಟ್ಟಿತ್ತು ಹೌದಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ? ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಕಂಪ್ಲೈಡ್ ಇಟ್ ವಿತ್ ಇನ್ 2 weeks? Already there is an order for dismissal. If it is not complied within 2 weeks, automatically it dismisses. ಇದೆ ಮಾಡಿಲ್ಲ. 5 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ರೀ. ತೊಳಿ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ರಿಕಾಲ್ ಹಾಕೊಳ್ಳಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಆಲ್ರೆಡಿ ದೇರ್ ವಾಸ್ ಎನ್ ಆರ್ಡರ್ 27/10/21. 3 weeks time was granted. Until that, office objection not complied, and hence dismissed as ordered earlier. 12 Pushparani. Same order madam, 27/10/21. 3 weeks not complied till date, dismissed. Gandhar 4/1/23. 1 ನಿಮಿಷ ನಾವೇನ ಕೊಟ್ಟಿದ್ವಿ. This matter is listed on 22 for non-compliance of office objection till date. Office objection not complied, even when the matter is listed for second time for non-compliance of office objection, there is no representation. Hence 2 weeks time granted to comply with office objections. If the office objections are not complied with, 2 weeks list this matter for dismissal. This matter was listed on 4/1/23, second time for non-compliance, and this appeal was filed in 2020, and there was no representation in the earlier occasion. However, this court granted 2 weeks time to comply with office objections. It also made it clear that if office objections are not complied within 2 weeks, list the matter for dismissal. And today also no representation, and hence dismissed for non-compliance. Dismissal of appeal in lieu of non-compliance of office objections. Matter was listed on 17/12 for non-compliance of office objection till date. Office objections are not complied, even when the matter is listed for second time for non-compliance or no present. The 2 weeks granted to comply with office objections. Office objections are not complied within 2 weeks. ಹೇಳಿ ಮೇಡಮ್, ಇವತ್ತೇನ್ ಮಾಡೋದಿಲ್ಲ, ಅದಕ್ಕೆ ಅಂತಲೇ 2 ವಾರ ಕೊಟ್ಟಿದ್ವಿ, ನೀವು ಮಾಡಿಲ್ಲ. ತೊಗೊಳ್ಳಿ. ಸೇಮ್ ಹಿಂದಿನ ಡೇಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ ಮೇಡಮ್, Adena in previous date of 4/1/23 till date not complied, but council seeks time today. But already given 2 weeks time to comply with, and in spite of it not complied it, and hence dismissed for non-prosecution.
Yes.
Bharat tell. 4/1/23 same madam, same similar order. Shivurama A to same. ಏನು ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟರು ಮಾಡಲ್ಲ. ಹೇಳಿ. ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇನೆ. Order if the office objections are not complied with within 2 weeks, this matter for ಅದ್ರ ಯಾವ್ದೇ ಆಗ್ಲಿ ನೀವು ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ. ಯಾವಾಗ ಅದ್ರ ಮೇಲೆ ಇದೆ ರೀ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಸರಿಯಾಗಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಆಫೀಸಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು. ಮಾಡಿಲ್ಲ ನೀವು ಯಾವ್ದಾರು ಮಾಡಿ
ಅಂತ ಇದೆ.
DCF make good ಆಮೇಲೆ
Provision court fee paid in RA and RSA to be stated correctly in the valuation para.
Huh.
Court fee paid in this court to be stated in the valuation para.
Huh.
Corrections to be carried out in IAS affidavit before competent authority.
ಅದೇನು ಮಾಡಿಲ್ಲ, ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ. ಕಟ್ ಬಂದಿದ್ದೀರಲ್ರಿ ನೀವು, ಕಟ್ಟಿದ್ದಾರಲ್ಲ, ಕಟ್ಟಿದ್ಮೇಲೆ ತಗೊಂಡೋಗಿ ರಸೀಟ್ ತೋರಿಸ್ಬಿಟ್ಟು ನಾ ಕಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು. ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರ್ರಿ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಸ್ಟೇಟೆಡ್ ಎನಿಥಿಂಗ್ ಇನ್ ದಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್. ಅದನ್ನ ಇನ್ನೊಂದ್ಸರಿ 2 ಸರಿ ರಿಪೀಟ್ ಮಾಡ್ಬೇಕಾ ನಾನು? ಆಯ್ತು ಕೌನ್ಸಿಲ್, ಈಗ ಏನು ಡಿಸ್ಮಿಸಲ್ ಇದೆ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಡಿಸ್ಮಿಸಲ್ ಇದೆ. ಇನ್ನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಎಟ್ ಕಂಪ್ಲೈಡ್. Sorry, madam. This matter was on 4/1/23. And earlier also it was listed for 21/10/21 for non-compliance of office objection. In spite of matter was listed for second time, office objections are not complied, and there was no representation, and hence this court granted to comply with office objections. We granted 2 weeks time to comply with office objections, and if in spite of it, office objections are not complied. And also earlier order is very clear that if office objections are not complied within 2 weeks, list the matter for dismissal on 19/1/23. And today council appears and submits that he has complied with office objections. And on verification of the office note, other office objections are not complied, and hence appeal is dismissed for non-prosecution. Mohammed Tahir A. Say madam earlier order then no. ಹೇಳಿ ಕೌನ್ಸಿಲ್. ಈಗೇನ್ ಕೊಡೋದಿಲ್ಲ, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇದೆ ಡಿಸ್ಮಿಸಲ್. ಡಿಸ್ಮಿಸ್ಡ್ ನೋಡಿ, ಡಿಸ್ಮಿಸ್ಡ್ ಅಯ್ಯ ಹಾಕೊಳ್ಳಿ. ಆಮೇಲೆ ನೋಡೋಣ ಮತ್ತೊಂದ್ಸರಿ 10,000 5,000 ಕಾಸ್ಟ್ ಹಾಕೋಣ, ಅವಾಗ ಸರಿ ಆಗುತ್ತೆ. ವರ್ಷಾನ್ಗಟ್ಲೆ ಕಂಪ್ಲೈ ಮಾಡಬೇಡಿ. 19 ಕರೆದಿ 19 ಅಲ್ವಾ ಈಗಲ, ಅವಾಗ ಮತ್ತೆ 19 ಅಂದ್ರೆ ಸೇಮ್ ಆರ್ಡರ್ ಮೇಡಮ್. ಇದು ಕೂಡ 20 ME ಮಹೇಶ್ವರಪ್ಪ. 20,000 ಡಿಪ್ಸಿಟ್ ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಸ್ಟ್ ಹಾಕಿದ್ವಿ, ಮತ್ತೆ ಅಪೀಲ್ ವಿಲ್ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಏನ್ ಮಾಡಿದಿರಿ? ಡೆಫಿಸಿಟ್ ಈಗ ಕೊಟ್ಟಿದ್ವಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಒಂದಲ್ಲ ಎರಡಲ್ಲ. ಸೇಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದೀವಿ, 2 weeks ಟೈಮ್ ಕೊಟ್ಟಿದೀವಿ, ನೀವು ಮಾಡಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ಡ್. ಒಂದಲ್ಲ ರೀ, ಬರೀ ಎಲ್ಲ ಹಿಂಗೇನೆ ನೋಡಿ, ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಆಯ್ತು, ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಮಾಡಿಲ್ಲ ಏನಿಲ್ಲ, ಆಫೀಸ್ ಟೈಮ್ ಕೊಟ್ರು ಮಾಡೋದಿಲ್ಲ, ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಏನ್ ಮಾಡ್ಬೋದು? ಅದ್ರಲ್ಲಿ ಮೇಡಮ್ ಕಾಸ್ಟ್ ಫೇರ್ ಹಾಕಿತ್ತು, ಲಾಕ್ ಅದನ್ನು ಬರೀಬೇಕು, ಕೊಡಿ. ಅಂಡ್ ದಿಸ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅಡ್ಜರ್ನ್ ದಿ ಮ್ಯಾಟರ್ by granting 2 weeks time to and payment of cost, and cost also not paid, and office objections also not complied. And in view of the earlier order for dismissal, for the appeal for non-compliance, appeal is dismissed for non-compliance. 21 ಮಂಜುನಾಥ TM. ಇದು ಕಾಸ್ಟ್ ಇಲ್ಲ ಮೇಡಮ್, ವಿತೌಟ್ ಕಾಸ್ಟ್ 4123 ಡೇಟ್ 2 weeks time granted, not complied with. Dismissed. Reddy YS dated 4123, idrallu ಅಷ್ಟೇ 2 weeks time granted, no cost. Dismissed. MV Maheshwarappa same idrallu ಅಷ್ಟೇ urgent and cost of ₹500 payable at registry, same cost not paid, objections not complied and hence dismissed. 24 Sanat Kumar Shetty. ಯಾವ 11 ಮಾಡಿದಾರೆ ಅಂತ ನೋಡಿ ಮೇಡಮ್, ಇದ್ರಲ್ಲೇನು 11 ನಾನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀನಿ ಅಂತಾರೆ ನೋಡಿ. Dismissal of appeal for non-compliance of office objection numbers. Office objections number 1 to 4 ಅಂತ ಇದೆಯಲ್ರಿ? ಸ್ಕ್ರೂಟಿನಿ ಅಲ್ಲ ಅದು ನೋಡಿ, ಅದು ಮೊದಲೇ ಇತ್ತು, ಅದು ಮತ್ತೆ ಮಾಡಿದಾರ ನೋಡಿ. Dismissal of appeal for non-compliance of office objections 1 to 4 ಏನಿದೆ ನೋಡಿ.
Sir, 1 to 4 ಅಲ್ಲಿ respondent number 5, 6, 9, 10, 11 and 14. ಮಾಡಿದೀರಾ? Stated to be dead at the cost title. Stated to be dead at the cost title, note in the judgment of RA. But they are parties to this appeal, clarify ಅಂತ.
ಅಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ, ಇಲ್ಲಿ ಪಾರ್ಟಿಗಳು ಮಾಡಿದಿರಿ ಅಂತ ನೀವು ನೋಡಿದ್ರೆ ಡೆಡ್ ಅಂತೀರಿ. ಹಾಕಿದಾರ ನೋಡಿ, ಅದನ್ನ ಆಫೀಸ್ ಫ್ರೆಶ್ ಆಗಿ ಹಾಕಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವಾಗ ಹಾಕಿದಿರಿ ಫ್ರೆಶ್ ಆಗಿ? ಎಲ್ಲಿ ಡಿಲೀಟ್ ಆಗಿಲ್ಲ ರೀ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, ಎಲ್ಲಿದೆ ನೋಡಿ ಕಾಸ್ ಟೈಟಲ್ ಡಿಲೀಟ್ ಆಗಿಲ್ವಲ್ಲ. ಅವ್ರಿಗೆ ಕೊಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಅವ್ರಿಗೆ ಕೋರ್ಟ್ ಮಾಡಕ್ ಹೇಳಿ, ಅವ್ರಿಗೆ ಹೇಳಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇನ್ನೊಬ್ರಿಗೆ ಕ್ಲಾರಿಫೈ ಮಾಡಕ್ ಹೇಳಿ. ಕೊಡಿ ಫೈಲ್, ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಡಿಸ್ಮಿಸಲ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ವಿಲ್ ನಾಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ. 55 HK ಕೆಂಚೇಗೌಡ ಹೇಳಿ. ಈಗ ಟೈಮ್ ಕೊಡಕ್ದಿಲ್ಲ, ಟೈಮ್ ಆಲ್ರೆಡಿ 2 ವಾರ ಕೊಟ್ಟಿದೆ. ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಇದೆ, ಡಿಸ್ಮಿಸಲ್ ಆಗ್ತದ ಅಷ್ಟೇ ನೋಡಿ. ಸೇಮ್ ಮೇಡಮ್ 4123 this court wide order dated 4123, this court granted 2 weeks time to comply with office objections, and office objections are not complied within 2 weeks. An order is passed to list the matter for dismissal, and in view of non-compliance, appeal is dismissed. Next one, Usha MV waiting service of notice in respect of R225. ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು? ಕೊಟ್ಟಿರೋದು ಯಾವಾಗ? ಅವರು ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ? 10/1 ಆರ್ಡರ್ ಆಯ್ತು, 17/1 ಇಶ್ಯೂ ಆಗಿದೆ. ಆಯ್ತು, ಅವಾಯ್ಡ್ ನೋಟಿಸ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ R225. ದಿಸ್ ಮಾಡಿ 17 ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ 17 ಮೇಲೆ ಕೊಡಿ. 20th of February. Service of notice in respect of refuse R10.
I'm appearing in this serial number 2, Your Lordship.
Appearing for?
Appellant, Your Lordship.
The notice issued against R10 was returned with an endorsement refused and hence held sufficient against R10. Next. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಮ್ಯಾಟ್ರ್ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ, ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಅಲ್ಲ ರೀ 2007, ಬಟ್ ಇನ್ನೂ ಸರ್ವಿಸ್ ಆಗಿರ್ಲಿಲ್ವಾ? ಅದು ಕೊಡಿ ಮೇಡಮ್, ಯಾವ್ದು ಕೊಡಿ. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ 6th of February. ಈ ಮಹೇಶ 13/1 ನೆಕ್ಸ್ಟ್ ಕೊಡಿ. ಅವೈಟ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R1 and R2. This matter on 15/2. Discrepancy in the date of judgment that of RA decree along with counsel submission. ಏನಾಗಿದೆ? ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಅದೊಂದೇನಾ? ನಾನ್ ಅರೇಯಿಂಗ್ ಆಫ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 in OS as a party to RA. RA ನಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ? ಯಾರು ಮಾಡಿದ್ದು? RA ಯಾರು ಹಾಕಿದ್ದು? ನೀವೇನ? ನೀವ್ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ? ಅಲ್ಲ ಆಫೀಸ್ ಅದಕ್ಕೆ ನಿಮ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಏನ್ರಿ ಹೇಳ್ರಿ? ಯಾವ್ದ್ರಲ್ಲಿ? ಸರಿ, ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲಲ್ಲ, ನೀವ್ ಏನ್ ರೀಸನ್ ಕೊಟ್ಟಿದ್ರಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಅಪೀಲ್ ಅಲ್ಲಿ ಬರೀ ಸೆಕ್ರೆಟರಿ ಮಾತ್ರ ಮಾಡಿದಿರಿ, ಹೌದಾ? ಇಲ್ಲಿ ನೋಡ್ರಿ KR ಸಾಗರ ಅಂತ ಇದೆ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಯಾವ್ದೋ ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬೆಳಗೊಳ ಹೋಬಳಿ ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕು ಕೃಷ್ಣರಾಜ್ ಸಾಗರ. ಏನ್ ಬೇಕಾಗಿಲ್ವ ನಿಮ್ಗೆ ಅವ್ರ ಪಾರ್ಟಿ? ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. The office has raised the objection regarding discrepancy in the date of OS judgment with that of RA decree. And having taken note of the typographical error, office objection is overruled regarding discrepancy of date. Next, the counsel appearing for the appellant would submit that in the appeal also, the defendant number 1 was not added as party and no relief is sought against the defendant number 1, and hence he has not been made as party, and hence counsel submission is accepted. Post the matter. Mood andre yaar ನೀವು ಯಾರು ಮೆಮೊ ಹಾಕಿರ್ಬೇಕು, ಅವ್ರು ಅದರ್ ಸೈಡ್ ಹಾಕಿರ್ಬೇಕು. ನೋಟಿಸ್ ಯಾರು ವಕಾಲತ್ ಹಾಕಿದಾರೆ ನೋಡಿ, KV ನರಸಿಂಹನ್ ವಕಾಲತ್ ರಿಟರ್ನ್ ಸಿನ್ಸ್ ನೋಟಿಸ್ ನಾಟ್ ಆರ್ಡರ್ಡ್ ಅಂತಿದೆ. ಅವರೇ ಮೂವ್ ಮಾಡಿರೋದಾ? ಅದೇ ಹೇಳಿ. ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. Memo for retirement filed by counsel for appellant Latif B. ಹೇಳ್ರಿ. Acknowledgement ಕೊಟ್ಟಿದ್ದೀರಾ? Non compliance of office objection for third time. ಬರೀ ಕಾಪಿ ಆಫ್ ಲೆಟರ್ ಹಾಕಿರ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲಿದೆ, ಪೋಸ್ಟಲ್ ರೆಸಿಟ್ ಅಲ್ಲಿದೆ. ಯಾವ ಆಫೀಸಲ್ಲಿ? ಅವ್ರದಲ್ಲಿ ಸೈನ್ ಇದೆ, ಪಾರ್ಟಿ ಸೈನ್ ಎಲ್ಲಿದೆ, heirs ಸೈನ್ ಇದೆ, ಅವ್ರು ಬರ್ದಿರೋದಾ? ಪಾರ್ಟಿನೇ ಬರ್ದಿರೋದು. ಸುಲೇಮಾನ್ ಬೇರಿ ಸೋನ್ಸೋ. ಯಾವ ಡೇಟ್ ಅಲ್ರಿ ಇದು? 4/12 ಅಲ್ಲ, 4/12 ಕೊಟ್ಟಿರೋದು ನೋಡಿ. ಅವ್ರೇನು ಇದು ಮಾಡಿದ್ದಾರೆ, ಯಾರು ಅಂಗ ವಕಾಲತ್ತನ್ನು ಹಾಕಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಆಫೀಸಲ್ಲಿ ನೋಡಿ. ದಿ ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಮೆಮೋ along with letter of counsel has filed memo of retirement dated 8/12/22 along with copy of the letter of the appellant dated 4/12/2022. Herein the appellant had stated that he has received the entire records. And ಯಾರೋ ಬೇರೆಯವ್ರಿದ್ದಾರೆ, ಪಾರ್ಟಿ ಯಾರೋ ಬೇರೆಯವ್ರು ಇದ್ದಂಗಿದ್ದಾನೆ, ಇಲ್ಲವಲ್ಲ? ಮತ್ತೆ on the instructions of appellant ಅಂತ ಬರೀತಾನೆ. Since appellant is suffering from heart ailment and he could not travel from Bangalore, hence I hereby taken records from the counsel. Undertakes that I will engage other counsel as soon as possible ಅಂತಿದೆ. On the instructions of appellant ಅಂತಾನೆ, ಇವನೇ ನೋಡ್ರಿ appellant ಏನೇ ಸುಲೇಮಾನ್ ಬೇರಿ. Until date, the appellant has not engaged the counsel and paper was taken on 4/12/22 and hence is this matter in the second week. Date ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್, ಯಾವ ತರ ಡೇಟ್ ಕೊಡಿ? 6th of February. If appellant not engages the counsel as undertaken given in the letter, appeal will be dismissed for non-prosecution. ನಿಮ್ಮ ಅವತ್ತು ಕೊಡ್ತೀನಿ ರಿಟೈರ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀವಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ. Non compliance of office objections raised on paper. Signature not forthcoming ಅಂತ. ಆಯ್ತು. The council is permitted to make the signature in the paper book. ಅಷ್ಟೇನಾ ಅದೊಂದೇನಾ? ಏನಯ್ಯ ಅದು? ಡೈರೆಕ್ಷನ್ ಇವತ್ತೀಗ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ. ಇವತ್ತು ನೀವು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ, ಹಿಯರಿಂಗ್ IAS ಅವತ್ ಮಾಡೋಣ. ಆಯ್ತು, ಯಾಕೆಂದ್ರೆ ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ಇದಾರ. ಹಾ 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 ಆಯ್ತು. ಹಿಯರಿಂಗ್ IAS ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ, ಅವತ್ತು ಮಾಡೋಣ. ಒಳ್ಳೆ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಹಿಯರಿಂಗ್ IAS interlocutory applications. ಮಾಡಿದ್ನಲ್ಲ, permitted to make signature the paper book. Next, Ramakrishna MG, non-arraying of depend number 2 RA as party OS and RSA along with the council submission. ಹೇಳಿ ಏನಾಗಿದೆ? ಅದು ನಾಟ್ ಪ್ರೆಸ್ ಆಗಿದೆಯಾ? ಆರ್ಎನಲ್ಲಿ ಮಾಡಿ ಮತ್ತೆ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡಿದಾರ. ಬಟ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ, ಒರಿಜಿನಲ್ ಸೂಟಿ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ. ಏನ್ ಹೆಸರು? ಪಾರ್ಟಿ ಹೆಸರು ಓಮ್ಮ ಶಿವಲಿಂಗಯ್ಯ. ತಗೊಳ್ಳಿ. The council appearing for the appellant would submit that the ಮತ್ತೆ ಇದಾರೆ ನಾನು ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಅಂತಾರೆ ಇಲ್ಲಿ. ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಇಲ್ವೇ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. Appellant counsel submits that the BDIA is not the party in the verse number 111 of 2005. However, while filing IA by the defendant, while filing the RA, the defendant arrayed the BDIA as respond number 2 and later not pressed the appeal against said Bilianna and hence not made the said Bilianna as party in this second appeal and hence council submission is accepted. Move ಮಾಡಿರೋದು ಯಾರಿದು? ನೀವೇನಾ? ನೋಟಿಸ್ ಆಮೇಲೆ ನೋಡೋಣ. ಪೋಸ್ಟ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅವಾಗ ಇದ್ರೆ ಗ್ರೌಂಡ್ ಇದ್ರೆ RSA ನಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ಆಯ್ತ್ರಿ, ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. SV Prakash, non filing of paper books. ಮೊದಲನೆಷ್ಟು ವಾರ ಕೊಟ್ಟಿದ್ರು, ಟ್ಯಾಕ್ ಮಾಡಲಿಲ್ಲ. 4/11/22 ಆಯ್ತು. The appellant counsel seeks another 4 weeks time to comply to file paper book. ಮತ್ತೆ 4 ವಾರ ಬೇಕ್ರಿ? ಹೇಳಿ ಮೇಡಮ್. ನಳಿನ ಫಾರ್ ಆರ್ಟ್ ಅಂತಿದೆ. ಕೊಡಿ ಮೇಡಮ್. Permitted to file paper book ಆಯ್ತು. undertakes to file ವಕಾಲತ್ for respond number 2 ಅಂತಿದೆ. ತೊಗೊಳ್ಳಿ. The appellant counsel seeks 4 weeks time to file paper book and 4 weeks time granted. Issue notice against respond number 2. Since counsel Srimati K. Nalina submits that the parties are not in cordial terms and hence could not file ವಕಾಲತ್ and hence issue note ಮೊದಲೇ ಹೇಳಿದ್ನ, hence issue notice against R2. Non-stating of valuation para of appeal correctly. Non-stating of schedule correctly. At IA. ಯಾವ್ದು ಓವರ್ರೂಲ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. RSA 885 ಯಾರ್ದ್ರಿ ನಿಮ್ದೇನಾ? ನಾನ್ ಸ್ಟೇಟಿಂಗ್ ಆಫ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ ಅಪೀಲ್ ಕರೆಕ್ಟ್ಲಿ ಅದನ್ನ ಮಾಡಕ್ಕಾಗಿಲ್ಲ. ಆಯ್ತು. ನಾನ್ ಸ್ಟೇಟಿಂಗ್ ಆಫ್ ಶೆಡ್ಯೂಲ್ ಕರೆಕ್ಟ್ಲಿ ಅಟ್ ಅದನ್ನು ಮಾಡ್ಬೇಕು ನೀವು. ಮತ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 3 to 7 along with council submissions at flag A ಅಂತಿದೆ. ಅದೇನ್ ಅದೆಲ್ಲ 3 to 7 ಏನ್ ಮೇಡಮ್ ಕೊಡಿ. 3 to 7 3 husband and father name of appellant number so and so are differs with that of a trial court clarify. ಅದೇ ಹೇಳಿದ್ದು. ಒಬ್ರದಲ್ರಿ 6 ಜನದ್ದು. ಏನ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೊಡಿ. ಫ್ರೀರಾ ಒಟ್ಟಿಗೆ ಕೊಟ್ಟಾರ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 4 ಮಾತ್ರ ಕೊಟ್ಟಾರೆ. Section number 4 RA 30 of 21 disposed on 20 which is rightly mentioned cost item of the judgment ಅಂತ ಬರ್ದಿರಿ. ಏನು typographical error of the office of the first appellate court in last line of judgment of RA date of judgment mentioned as 28/1/22 instead of 28/2 na. The office of the council submission regarding office objection number 4 is accepted since there is only a typographical error. Next serial number 5 to 10 ena ide individual name along with council submission flag A. The office objections number 5 to 10 are interrelated in judgment and declare first appellate court due to typographical error mentioned the name of Bandli Saab as Bandagi Saab. Please predecessor to appellant number was also appeal. Those are respond number 127,715. Husband of the respond number 12 is Munir Saab due to typographical error in the judgment mentioned as Munir. Husband name of the respondent number 16 is Likayat Ali. Due to typographical error in judgment of RA mentioned as Likayat. So the other officers objections are also with regard to the typographical error crept in mentioning the name of husband of respondent number 12. Also mentioning the name of Bandli Saab as Bandagi Saab. Is predecessor to appellants number 127,1115 of the appeal. And council submission are accepted. Regarding other office objections, council takes 2 days to comply with office objection. If office objections are complied with, post the matter for admission. As per roster. Ishwara Bhatt non-filing of certificate copy of valuation slip. ಬೇಸಿಸ್ ಮೇಲೆನೆ ಕೋರ್ಟ್ ಫೀ ವ್ಯಾಲ್ಯೂ ಮಾಡೋದು ಇಲ್ಲ ಆದ್ರೂ ಅಲ್ವಾ ಹಾಕ್ಬೇಕು ನೀವು. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅದು. ಎಷ್ಟಿಸಬೇಕು ನೀವು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಕೊಟ್ರೆ ನಾವು ಆಮೇಲೆ ಅಪೀಲ್ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ತೀವಿ. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ 2 weeks time and hence 2 weeks time granted to comply with office objections. Non-filing of acknowledgement for having served copies. ಮಾಡಿದೀರಾ ಯಾವಾಗ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಟ್ಟಿಲ್ಲ. ಕಾಪೀಸ್ ಬಂದಿದೆಯಾ ಮೇಡಮ್? The council appearing with the respondent would submit that she has received the appeal memo and also the IAS. IA again objections ಇದೆ 12 ದಿವಸ ಇದೆ. Heard on IA 1 of 17 and there is a delay of 17 that results in filing the appeal and for the reasons mentioned in the IA delay of 20 days is condoned. Post the matter for admission. Permission to implead as respondent. IA 1 of 23 for pleading. And why there are 2 IAs? IA 1 of 23 filed by whom? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾ 1/22 ಫೈಲ್ ಮಾಡಿರೋದು ಯಾರು ಅವ್ರಾ ನೀವ್ ಯಾರನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಂಪ್ಲೀಟ್ ಮಾಡಕ್ ಹಾಕಿದ್ರಿ ಹಾ ಎಲ್ಲಾರಾದ್ರೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ವಾ ಹಾ 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 ಅದು ಲೀವ್ ಕೇಳಿದಿರಿ ಹಾ objection sir okay whether he is in LR or not ಟ್ರಸ್ಟಿ ಆಗ್ಲಿ ಬಟ್ ಅವ್ರು ಎಲ್ಲಾರು ಹೌದಾ ಅಲ್ಲ ಹಾ ಹಾ Dinakar, whether he is represented in the suit and appeal in an individual capacity or managing trustee. ಈಗ ಮ್ಯಾನೇಜಿಂಗ್ ಟ್ರಸ್ಟಿ ಬೇರೆಯವ್ರನ್ನ ಮಾಡಿದಾರ ಅಮ್ಮ ಆಗಿದಾರ
and it's a suit for declaration.
That has been dismissed. Huh? No.
Can be disposed of.
ಅದೇ ರೀ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂದ್ರೆ ಏನಂತ ಮಾಡ್ಬೇಕು ಆಲ್ರೆಡಿ ದೇರ್ ಇಸ್ an order by the court
There is an order in the
then we have to make writtenly not necessary ಅಂತ ಮಾಡಿದಾರಾ not necessary to make the wife as party to the proceedings ಅಂತ ಆಗಿದ್ಯಾ ಏನಂತ ಆಗಿದೆ ಹಾ ಹೇಳಿ writ against which order impleadment of an application was filed before the trial court the same came to be dismissed allowed some other suit ಅಲ್ಲ some other suit ಆಯ್ತು ಆ ಸೂಟ್ ನಲ್ಲಿ ಈ ಸೂಟ್ ಅಲ್ಲಿ ನೀವೀಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾರನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀರಿ ಆದಿತ್ಯ ಅಂದ್ರೆ he is now the managing trustee suit for injunction only hereditary officer
It's not a hereditary office.
ಆಯ್ತು ಟ್ರಸ್ಟ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಇದು ಟ್ರಸ್ಟ್ ಮತ್ತೆ ಕೇಳ್ತಾ ಇರೋದು ಅಲ್ಲ ಈಗ ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ ನೀವು ಆದಿತ್ಯ ಈಗ ಪ್ರೆಸೆಂಟ್ ಟ್ರಸ್ಟಿ ಆಯ್ತು ಪ್ರೆಸೆಂಟ್ ಟ್ರಸ್ಟಿ ಹೌದಲ್ಲ ಹಾ ಥರ್ಡ್ A number 1/23 for impleading and also A 1/22 for permission to implead as respondent. A number 1/23 is filed by the respondent and sought for an order to implead one Aditya, who is the present trustee, and his presence is necessary to decide the issue involved between the parties. That is our ground, their ground. ನೀವು ಅದಕ್ಕೆ ಕೈಯಾಗ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ 1/23 1/23 ಅದು ಪ್ರೊಸೀಡ್ ಆಗ್ಬೋದು ಅದಕ್ಕೆ ಕೇಳಿದ್ವಿ A number 1/22 filed by the appellant bringing the LR of earlier trustee Mr. Dinakar, who is no more. And the proposed respondent is wife of is at Dinakar. Suit is filed for the relief of injunction. And injunction ಏನಾಯ್ತು ಅವಾಗ? Injunction suit was decreed against the judgment and decree. An appeal is filed in RA number 64 of 2016. And after the disposal of RA number 64 of 2016, the respondent in RA, Mr. Dinakara, was passed away. And hence, an application is filed by the appellant to bring the LR up, bring the wife as LR. Admittedly, the Dinakar was the trustee. Dispute idea. And they said Dinakar, in his capacity as trustee, was arrayed as plaintiff ಅವನೇ ಹಾಕಿರೋದಲ್ಲ ದಿನಕರ್. ಅವನು ಇದ್ದಾರೆ, ದಿನಕರ್ ಇದ್ದಾನೆ. ದಿನಕರ್ ಸೆಕೆಂಡ್ ಇದಾರೆ. Earlier suit was filed by Dinakar as well as Narayan Pujari. ಅವರು ಸತ್ತೋಗಿದ್ದಾರೆ, ನಾರಾಯಣ್ ಪೂಜಾರಿ. And Narayan Pujari also passed away during the pendency of the original suit, and subsequently Dinakar was added as plaintiff. And in the capacity of the trustee, said Dinakar agitated the matter, and having taken note of the said fact into consideration, as well as in other suits as contended by the respondent counsel, that an application was filed before the trial court in other suits by Srimati ಈಗೇನ ಹೆಸರು ಅವ್ರದ್ದು? ಆದಿತ್ಯ ಅಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಆದಿತ್ಯ ಅವ್ರದಲ್ಲ. ಆಯ್ತಾ? ಏನಾಯ್ತು ಮೇಡಮ್? By one Aditya as trustee, applications are allowed and the same has been challenged in the writ petition, and writ petition was also dismissed. And in connected suits, he said Aditya as arrayed as party to the proceedings, and having taken note of the said fact into consideration, and also the dispute involved between the parties also with regard to the trust and also the trusteeship, and hence the IA filed by the respondent, IA number 1/23 is allowed, and IA number 1/22 filed by the appellant to implead the wife of Dinakar as party is rejected. And accordingly, the appellant counsel is directed to amend the cost title. List the matter of cost title and file amended cost title within 2 weeks. 2 weeks. List the matter for admission on 2 ವಾರ ಬಿಟ್ಕೊಡಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿ. ಏನೋ ಪುಂಡಿಕಾಯಿ ಈಶ್ವರ್ ಭಟ್ ಹೇಳ್ರಿ ಏನು? ಕಾಪಿ ಆಫ್ OS ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಂತಿದೆ. ಸರ್ಟಿಫೈಡ್ ಹಾಕಿದೀರಾ? ಕೇಳಿರೋ ಸರ್ಟಿಫೈಡ್ ಹಾಕಿ ಅಷ್ಟೇ. ಅವ್ರು ಕೇಳಿರೋದು ಅಷ್ಟು, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ OS ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ 10 ದಿವಸ. ಅಂದ್ರೆ ಹಿಯರಿಂಗ್ ಬೇಕು, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಡೇಟ್ ಕೊಟ್ರೆ ಅವತ್ತಿಗೆ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೊಂದು ಸರಿ ಡೇಟ್. Bringing the LRs of deceased R1 ಮುನಿವೆಂಕಟಪ್ಪ ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ? LRsಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಇಶ್ಯೂ ನೋಟಿಸ್, ಅದೇನ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ಒಂದೇ. Issue notice against the LRs of issue notice on IA number 2/22 against the LRs of deceased R1. A2 notice ಹೋಗ್ಬರ್ಬೇಕು A2 ಗೆ. ಆಯ್ತ್ರಿ, LRs ನ ತರದಲ್ಲ ಆರ್ಡರ್ ಮಾಡಕ್ಕಾಗತ್ತ ನಾವು? ಚೇಂಜ್ ಮಾಡಿದ್ರು ಏನಾಗುತ್ತೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ರಿಸಲ್ಟ್ ಆಫ್ ದಿ ಅಪೀಲ್ ಅಷ್ಟೇ. ಫಸ್ಟ್ ಎಲ್ಲಾರ್ಸ್ ತಗೊಬನ್ನಿ ರೆಕಾರ್ಡಿಗೆ ನೀವು ಎಲ್ಲಾರ್ಸ್ ತರದಲ್ಲಿ ಹೇಗೆ ಆರ್ಡರ್ ಮಾಡೋದು. ಇಲ್ಲ ಅವ್ರಿಲ್ಲ ತಂದ್ಬಿಡಿ ಎಲ್ಲಾರ್ಸ್ ತಂದ್ಬಿಡಿ ಅಷ್ಟೇ. ಬೇಕಾ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಬೇಕಾ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಬೇಕಾ? ಅದೇ ಎಲ್ಲಾರ್ಗೇನೆ ಅವೇ ಹಾಕಿದಿರಿ ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ ನಾನು. ಎಲ್ಲ ಬೇರೆಯವರೆಲ್ಲ ಯಾರ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ ಕೆ ಕೌನ್ಸಿಲ್ ಇದಾರೆ ನೋಡಿ. R2 R3 ಎಲ್ಲ ಇದಾರೆ ನೋಡಿ. ಹೆಂಗ್ ಸ್ಟೇಟಸ್ ಕೊಡಕ್ಕಾಗತ್ರಿ ವಿತೌಟ್ ಬ್ರಿಂಗಿಂಗ್ ದಿ ಪಾರ್ಟೀಸ್. ಆಯ್ತ್ರಿ ಸತ್ತರ್ ಮೇಲೆ ನಾನು ಆರ್ಡರ್ ಕೊಡ್ಲೇನ್ರಿ ಅನ್ಲೆಸ್ ಯು ಬ್ರಿಂಗ್ ದಿ LRs ಆನ್ ರೆಕಾರ್ಡ್. ಆಯ್ತು ಏನಾಗಲ್ಲ ರೆವಿನ್ಯೂ ಸ್ಟೇಟಸ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ರಿಸಲ್ಟ್ ಅಷ್ಟೇ. ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಹಾಕಿ ಬಂದಿದೆ ಎಲ್ಲ ಆಗಿದೆ. CD of 220 days delay. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನೀವೇನ್ Directed to serve the copy of the memorandum of appeal on the council of respond number 1 ಅಂತಿದೆ. Last occasional direction ಇದೆ. You are not there. You are not there and also direction was given. You serve the copy, that's all. The council sorry. This court void order dated 13/12/22 directed the appellant to serve the copy of the memorandum of the appeal on the council for respond number 1 until date not served. And hence directed to serve the copy of the appeal memo forthwith. ಇವತ್ತೇ ಕೊಡ್ತೀರಾ forthwith this matter on 6/2. M. Shivaprakash. ಇಲ್ವಾ ಶಿವಪ್ರಕಾಶ್ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೈಸ್ ಟೈಮ್ ತಗೊಳ್ಳಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಬರ್ಲಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. MR Nagbhushan. Agreed. 1, 2, 3 and 6, 4 and 5 rejected. D4 claim rejected. Modified in favor of D4 also. Held. D1 is brother. D2 purchaser. Some of the items. He is one more brother.
Claim of Partition number 4 and after the semi-declared by Partition number 1 create value 23/4.
That is item number 4 and 5.
Yes, ma'am. There
that is allowed. Modifying granting share to him also.
By cancelling my all the
ಈ ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ ಯಾವಾಗ 2019 ಅಲ್ಲಿ ಹೌದಾ ಸರ್ ದಟ್ ಈಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಜಜ್ಮೆಂಟ್ ಡಿಲೇ ಎಷ್ಟು ಇದೆ ಇದರಲ್ಲಿ ಡಿಲೇ ಇಲ್ವಾ ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು ಯಾವಾಗ 19 ಅಲ್ಲಿ ಹಾಕಿದಿರಿ ನೋಷನಲ್ ಅಂತ ಕೊಟ್ಟಿಲ್ವಲ್ರಿ 1/4 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾ ಟಿಕೆಟ್ ನಂಬರ್ 1 ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. ಪ್ಲೈಂಟಿಫ್ ಮತ್ತೆ ಈಕ್ವಲ್ ಶೇರ್ ಮಾಡಿದ್ರು. ಈಕ್ವಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ. ಹೌದು. ಅಪ್ಪ ತೀರ್ಕೊಂಡಿದ್ದೆ ಅವಾಗ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 4 ಯಾಕೆ ಶೇರ್ ಕೊಡ್ಲಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ವಾಟ್ ಈಸ್ ದ ರೀಸನ್ ಫಾರ್ ನಾಟ್ ಗ್ರಾಂಟಿಂಗ್? Modified by holding that defendant number 4 in the trial court is entitled for 2/6 share, a half share of his grandfather. Defendant number 1 and plaintiff, each of them are also entitled for 2/6 share in the half share of their father. The suit item number 1 to 3 and 6 by meets and bounds. What is the error in? Speak now. Appeal filed by the D4. Defendant number 4.
Defendant number RA. Defendant number 1.
That is the plaintiff. Father ತೀರ್ಕೊಂಡಿದ್ದೆ ಅವಾಗ. Whether on the date of filing the suit, whether father was alive or not? No. Siddhamma is the
daughter of the first late Anmaya.
Anmaya.
Is the father of the and
defendant number 4 grand. ಮಗಳು ಮಗ predeceased daughter's son. ಮದರ್ ಅವಾಗ ತೀರ್ಕೊಂಡಿದ್ದು. D4 ಮದರ್ ತೀರ್ಕೊಂಡಿದ್ದೆ ಅವಾಗ. ಹನುಮಯ್ಯ ತೀರ್ಕೊಂಡಿದ್ದೆ ಅವಾಗ್ರಿ. ಆಯ್ತು. ಹನುಮಯ್ಯ 3 ಜನ ಮಕ್ಳಿದ್ರು. 2 ಹೆಣ್ಮಕ್ಳು 1 ಮಗ. ಹೌದಾ? ಫಸ್ಟ್ ವೈಫ್ ಮೂಲಕ ಎಷ್ಟು ಮಕ್ಕಳು? ಅದೇನೆ ಒಟ್ಟಿಗೆ 3 ಜನ ಮಕ್ಕಳು. ಫಸ್ಟ್ ವೈಫ್ ಮೂಲಕ ಒಬ್ಬ, ಅಲ್ಲಿ 3 ಜನ ಇದ್ರು ಹನುಮಯ್ಯನ್ಗೆ. ಹನುಮಯ್ಯ ಡೈಡ್ ಇಂಟೆಸ್ಟೇಟ್. ಹೌದಾ? ಈಗ ಇನ್ನೊಬ್ಳು ಡಾಕ್ಟರ್ ಯಾವಾಗ ತೀರ್ಕೊಂಡಿದ್ದು? ಆಯ್ತು. ಇವನ್ ಅಸ್ಯೂಮಿಂಗ್ ದಟ್ the date is not mentioned, her LRs are entitled for share. ಹೌದಲ್ಲ? 1/3 ಶೇರ್ ಬರುತ್ತೆ.
Now the half of the share in the association property goes to the defendant number 1.
That issue notice. Issue emergent notice against the respondents. ಲಾಸ್ಟ್ ಟೈಮ್ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರಿ. ಎವ್ರಿ ಟೈಮ್ ಬರೀ ಪಾಸ್ ಓವರ್ ಕೇಳೋದ ನೀವು? ಮತ್ತೆ ಈಗ ನೀವು ಈಗ ಮಾಡಿದ್ರೆ ಮಾಡ್ಲಿ, ಇಲ್ಲ ನೀವು ಹೋಗ್ಬೇಕು. ಅವ್ರು ಹೋಗ್ಬೇಕಂತ ಈಗ. ನೋಡಿ, ಪಾರ್ಟ್ರಾಡ್ ಬೇರೆ ಇದು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಪಾರ್ಟ್ರಾಡ್ ಆಗಿದೆಯಲ್ಲ. ನೋಡಿ, the junior counsel seeks passover and counsel appearing for the respondent submits that he has got inconvenience since he has to attend funeral, and hence yavat ಬೇಕು. next time no passover business. ಆಯ್ತಾ? ಕೊಡಿ, ಒಂದೇ ಕೊಡಿ ಮೇಡಮ್. ಪಾರ್ಟ್ರಾಡ್ 6 to 9 ಕೊಡ್ತೀರಾ? ಮುಂಚೆ ಯಾವ್ದು ಇಲ್ವಾ? ಫಸ್ಟ್ ಆಫ್ ಫೆಬ್ರವರಿ. ಆಯ್ತು, 1st of February. 1st of February. 1st of February ಆಗಲ್ವಾ? 1st of February ಆಗುತ್ತಾ? ಹ? 5th ವರೆಗೆ ಟ್ರಯಲ್ ಇದೆ. 6th ಆಗ್ಬೋದಾ? ಆಯ್ತು 6th. ಹ್ಮ್ 19. ಹ್ಮ್ ಹ್ಮ್ ಹ್ಮ್
Respondent number 1 is
ಹ್ಮ್
there were other 6 sons.
Siddha Nanjappa had how many sons?
About the wife and 4 sons, 6 sons. Out of them, 2 died during the pendency of the suit. And
6 sons. 6 sons. Any daughters?
Daughters, no, daughters were there. 2 daughters.
2 daughters. Huh.
But the first plaintiff, the plaintiff in the trial court was the person who instituted suit for severe partition.
Huh.
8 items.
Hmm.
One of them being a house.
Hmm. Hmm. Hmm.
Very well. He set up his trade.
Hmm.
These are all the property acquired by my father, Siddha Nanjappa.
Hmm.
And the defendants are trying to, including his brother's demise wives,
Hmm.
they are trying to create a partition deed and attempting to change Kata.
Hmm.
So declare that I am entitled for 1 share. That is the sum and substance of the claim. In defense to that claim, his demise brother's daughters raised a defense.
Hmm.
Of course, items number 1 to 8 of the 1 to 7 of the cases were acquired by the
Hmm.
Siddha Nanjappa.
Hmm.
And they were partitioned
Hmm.
by a Alupati exhibit teaser
Hmm.
and registered down.
Hmm.
And in respect of 1 item of the property,
Hmm.
they contend that Siddha Nanjappa executed a will in respect of a portion of the property of the acres item.
Hmm.
A registered will.
Hmm.
Set up the defense.
Hmm.
Issue.
Hmm. Hmm.
Despite the suit of the plaintiff in respect of that item number 3 of the property, granted share in respect of
Other remaining.
and all other. 2 reasons right of the court of first instance
Hmm.
laid down in the judgment was the partition deed, though it is a Palupati,
Hmm.
gives a detailed account of each one got how much share,
Hmm.
what extent and where the property is found.
Hmm.
But one of the sons of Siddha Nanjappa has not signed the Palupati. Well, of course, I am not one of them.
Hmm.
Cannot be believed.
Hmm.
So there was a decree for partition in this. All the property except the property covered under the will in respect of defendant 9 and 10 was not touched. They were held to be the separate acquired property of Siddha Nanjappa. Therefore, he had every right in this world to leave everyone.
1/9 share was granted.
Granted, except in 1 acre, each
Which
item
was Subject matter of the will. Hmm.
So even the bill.
Conclusion that is not binding on these persons. Hmm. Hmm. Hmm.
This was not the plan. Nor he prepared a ground in the plaintiff with regard to the execution of the will and its validity.
Hmm.
There was no amendment running in the plaintiff at all. Only about the
Probably will was set up in the defense only in the written statement. That's there was no pleading in the plaint.
that it was substantially fraudulently obtained by the chief daughter-in-law, that is my demise brothers. Of course, it was there. In 2011, he challenged the mutation in respect of the will obtained claimed by defendant 9 and 10, that is his brother's wife. The matter had gone up to the highest level before the revenue court. For the wife, suppose the proceeding before the revenue court becomes secondary. Why I'm telling this? Though he had the knowledge of the date of filing of this about the will and the mutation obtained, he did not ask for a relief in concern with the as a lesser relief, major relief for partition. He allowed the suit only to be tried and evidence to be recorded on the basis of the partition date. And granted it. And my submission for my Lord's consideration is, if Order 7, Rule 7, of course, client is backed up with an government to support ground for the will, is free. Then the court, in absence of such a prayer, court can move the relief. Because the question of declaration of will becomes a lesser relief in the light of the major relief of decree for partition. This aspect will have to be read along with Order 2. Suit should include the
all.
Their jurisdiction. Just because I have pleaded in the written statement regarding the exhibit E7 as a will, all the courts have watched their jurisdiction in trying the validity of the will. Okay. I'm too happy because the court of first instance granted me a decree affect the validity of the will. First court should have in mind was partial decree. Or 7 bars the court to exercise the jurisdiction with regard to any findings on the will, on the ground that it has not and kindly
Why the reason for coming to conclusion that not binding on them? If will was executed by the father.
No, will was executed by the father of the defendant 9 and 10.
Original
Will was
Siddhan and Jappa, who is the owner of the entire properties. Howda?
no, let us say,
Property belongs to the Siddhan and Jappa only.
let us say, should they not prove that acquired of the family funds?
Is it their claim that the entire all the food properties are the self-acquired properties of Siddhan and Jappa?
Very So, in absence of
Whether the trial court considered with regard to the validity of the will, because the court comes defense, then once the person who claims based on the will, he performed the will. That's what.
The most examination itself, that was rightly appreciated. Of course, it question of me coming into the judgment of the suit of the plaintiff where the relief of partition is claimed would become a foreign.
Trial court considered the will and also validity of the will also. But the appellate court comes to the conclusion that it is not binding on them. Why the first appellate court comes to such a conclusion? It is not binding on them.
The date of execution of the will, though it is registered, though he was present before the court, and he has signed it in the presence of the witnesses, and those all formalities he has been taken, adopted, he was not enjoying the health. Since physically and mentally looks to be, as I read the judgment or some paragraph, he said in what sense he was not having a good health. Good health. I understand if a person is mentally unsounded to the degree which he cannot understand. Now, can you see the operative portion of the first appellate court judgment? It's a little funny.
That's why I asked why court comes to the conclusion. It is not binding. Read the operative portion, register will dated so and so executed in favor of 1 acre is not binding on the share of plaintiff and defendant number 6.
judge order. Suit of the plaintiff is decreed because plaintiff and defendant number 16 are entitled to concurrent share in all the suit scheduled property, including 1 acre. In the first leg of the operative portion of the order, he excludes 1 acre, the learned judge.
Yes.
The later he includes it.
That issue notice.
Lord, I state.
ಯಾವಾಗಿದೆ ಫೈನಲ್ ಡಿಗ್ರಿ ನಡೀತಾ ಇದೆ ಈಗ ಯಾವಾಗಿದೆ ಹೇಳಿ ಡೇಟ್ ನೋಟಿಸ್ ಓವರ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿ ಆಯ್ತು ಈಗ ಏನು ಫೈನಲ್ ಡಿಗ್ರಿ ಆದ್ರೂ ಇಟ್ ಟೇಕ್ಸ್ ಟೈಮ್ ಫಾರ್ ಡ್ರಾಯಿಂಗ್ ಫೈನಲ್ ಡಿಗ್ರಿ ನೋಟಿಸ್ ಓವರ್ಲಿ ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಆಯ್ತು ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಬರ್ತದೆ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಸೇಮ್ ಮಾಡ್ರಿ ಎರಡರಲ್ಲೂ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್
Second appeal. It's for declaration and intention. The plaintiff agreement of sale. Dated 97. But on the ground that he has challenged declaration that would be sale deed executed on the basis of the GPA. By the defendant number 1, the defendant number 2. It's not illegal on the ground. The agreement of sale executed actually is as a security to the law signed by him. In the agreement of sale, there is a condition that 50,000 rupees is paid to him. Remaining will be paid not at the time of registration. And possession will be given at the time of registration. Meanwhile, GPA is also given to the first defendant. On that basis, though he has not, one of the conditions the GPA is that he is entitled to sell the property. And receive the consideration and should be paid to the plaintiff and the accord. That has not been done. Both the courts have had. Since the plaintiff has admitted the execution of these two registered deeds, the agreement of sale and the GPA, the GPA coupled with the interest. And also held that I have not proved that these deeds actually protected as a security by not examining the witnesses. I also contend that in spite of that deeds, I continue to be in possession. All the revenue records are in the name of the plaintiff. The trial court has held that though the court that all the revenue records as on the date of and subsequently in the name of the plaintiff, that will not create any right on the plaintiff. That my submission is not there are two relief. One is not for declaration and injunction. That having got that there is the deeds are proved. The second point, that possession, on the basis of the evidence and the document, so that the plaintiff is in possession. To that extent, this court ought to have decreed the suit in the
sale agreement in whose favor?
Favor of the first defendant.
First defendant. And certified copy of the sale deed dated 3/3/2005 in whose favor? Second defendant. Executed by
First
defendant. GPA holder as well as the agreement holder. Agreement holder. Whether in terms of the GPA powers was given to him to sell the property also?
Yes, there is a power is given. Together, the agreement of sale as well as the GPA. The agreement of sale is concerned,
And agreement of sale also 24/2/1997. Possession was also delivered.
No,
In favor of the defend number one. No.
That
Huh.
at the time of registration.
Registration. Huh.
Each time, Lord, on the basis of the DPA is executed
Hmm.
in favor of the second defendant.
Hmm.
The plaintiff is continued in possession. So that aspect, Lord, has not been considered.
Hmm.
Though the entire record
Hmm.
show that Lord, up to date, that the plaintiff is in possession. The appellate court, Lord, even has not touched the aspect of the possession.
Hmm.
And Lord, with the order of the trial.
Sale deed was executed on 3/3/2005. Hmm.
Therefore, Lord, I challenge. It is
Exhibit P8 copy ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಪವರ್ ಪಟಾರ್ನಿ? ಕಂಟೆಂಟ್ಸ್ ಇದೆ ನೋಡಿ. ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವಿವರವಾಗಿ ನಮೂದಿಸಿರತಕ್ಕ ಸ್ವತ್ತನ್ನು ನನ್ನ ಸ್ವಂತದ ಕೆಲಸದ ಅನಿವಾರ್ಯದ ನಿಮಿತ್ತ ನೋಡಿಕೊಳ್ಳಲು ಮತ್ತು ನಿಗಾವಣೆ ವಗೈರೆ ಮಾಡಲು ಅನಾನುಕೂಲವಾದ್ದರಿಂದ ಇದನ್ನು ನನ್ನ ಪರವಾಗಿ ನಿಭಾಯಿಸುವುದರ ಸಲುವಾಗಿ ಕೆಳಕಂಡ ನಿಬಂಧನೆಗಳು ನಿಮಗೆ ಆಧಾರವನ್ನು ನೀಡಿರುತ್ತೇನೆ. That itself is sell.
Before that.
Huh.
That not possession it says.
Hmm.
Possession has not been given, it will be given at the time of registration.
ಕ್ರಯದ ಕರಾರು ಪತ್ರ. That is 24/2/97. 24/2/97. Huh.
ಸ್ವಾಧೀನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ. ಸ್ವಾಧೀನ ಕೊಟ್ಟಿಲ್ಲ.
₹50,000 ಮುಂಗಡವಾಗಿ ಪಡೆದು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಇನ್ನುಳಿಕೆ ಕ್ರಯದ ಹಣವಾದರೂ 5,000 ಮಾತ್ರ ಬಾಕಿ ಉಳಿಸಿಕೊಂಡಿರೋದು.
End of sale.
Hmm.
On the same day.
Hmm.
That shows. Not given.
Hmm.
And it will be given.
Hmm.
He executed on the very same day.
Hmm.
That shows not, of course, he could sell the property and receive the consideration and pay to the plaintiff. And not give an account. That not, he has not led evidence or proved that not attaching complaint. Meanwhile, the first defendant on the basis of the GPA, reversing the not the agreement of sale condition, he sells it to the second defendant who is the pro-brother. And not the possession is continued with the plaintiff.
Hmm.
All the records.
Hmm.
That not the plaintiff is in possession and entitled for injunction.
After the execution of the sale deed, all the documents are standing in the name of the
No,
defendant.
no, it's not. It is include the there are 20 and 26 of the page 70. The trial court case.
Hmm. Exhibit P7 clearly indicates that defendant number 1 is the power of attorney holder of the plaintiff. He sold the suitable property in favor of defendant number 1 for valuable sale consideration amount of 2,37,000. Therefore, the title over the suitable property is vested with defendant number 2 by virtue of the sale deed. Exhibit P9 is the mutation register extract and P20 the RTC extracts reveal the suitable property was standing in the name of the plaintiff and it continued even after the sale deed executed in favor of defendant number 2. However, the revenue records cannot confer title to the property. No doubt Exhibit P24 is the individualized certificate. So and so agriculture passport, none of the owner. Those documents are through standing in the name of the plaintiff does not confer title of the plaintiff since the registered sale deed has been executed in favor of defendant number 2. Suit was filed in the year 2005 after the execution of the sale deed.
Yes.
Have you sought any relief in the declaratory suit with regard to the sale deed?
That is the declaration and intention.
What is the prayer?
There that sale deed
Huh.
is claimed by executed is illegal and not binding on the plaintiff.
Well, once you have executed the power of attorney to execute the sale deed, how you can seek for the relief of declaration? Huh.
But another document read along with the agreement of sale executed on the very same day.
What is it?
That-
Huh.
That is not given to the first defendant.
But both are contrary to each other. Sale agreement as well as your power of attorney.
The court
Power of
says-
attorney discloses that all in order to maintain and manage everything, you have given the possession to in favor of the purchaser.
coupled with the interest.
Hmm.
Therefore, not the title has been passed on.
Hmm.
That is contrary to the not the possession is concerned.
Hmm.
Admittedly, not possession is not given to the first defendant.
Hmm.
All the record, even after the sale deed, not as on today, it is continued in the name of the plaintiff.
Yes, continuation because there was a sale already. Hmm.
Possession. Yes, Lord, they. In accordance with law, person found to be in possession. Is entitled for injunction.
You have already executed a power of attorney even for selling of the property after receiving the amount of 50,000 from him. Whether you have sought for relief of possession also.
No, no. We consider it not whether the law. Not writing not denying the relief of injunction. In spite of the evidence to show that the plaintiff has continued in possession as on the date of the suit, even after the execution of the plaintiff. But with the term in the agreement of sale that the possession has not given to the person. Therefore, what I am entitled for second of injunction, till them not they were obtained possession in accordance.
What are the documents you have filed under order 41/27?
Documents, I wanted to examine the witnesses.
Only witnesses. What happened that day?
That has been rejected in the appellate on the ground that after the dismissal of
Hmm.
not
Whether that order is challenged,
very simply,
whether that order has been challenged on that.
including the present challenge. Along with
But whether that IA is considered separately or main ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇದೆ. You watch up
Confirmed ಅಂತಿದೆ.
7.
ಸಪರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಂಡ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಇಲ್ವಲ್ಲ?
ಇದರಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ.
ಇದೆ ಫಸ್ಟ್ ಇಶ್ಯೂ.
Okay.
Has made out any ground to allow the application filed under order 41/27. If it is a security document, why you have given the power under power of attorney to sell the property?
This is
Your case is that it is only a security document, avoid the loan. Then why you gave the power for selling of the property, if that is so?
taking advantage.
No, you are not disputing the document of execution of the sale agreement as well as the power of attorney.
Yes.
Then.
First document agreement of sale. That shows that the possession will be given at the time.
You are not answering to my question. Your case is that it is only a
Yes.
sale transaction, security document, you have executed the document. If that is so, why you gave the power to execute the sale deed in favor of the prospective buyers, in favor of defendant number 1?
My case. Taking advantage.
Oh, no, that is not your case. You go to issue, first number, issue. Whether the plaintiff proves that he is the absolute owner in possession and enjoyment of the social property on the basis of the registered sale deed dated 12/4/1990.
Yes,
That is not disputable. Whether the plaintiff further proves that he has executed a nominal agreement of sale deed 24/2 sale deed or sale agreement and the general power of attorney in favor of the defendant number 1 in respect of the suit property as a security for the loan of rupees 50,000 obtained from the defendant antide. Then why you gave the power to the defendant number 1 to sell the property if that is the only a sale transaction and nominal document? If it is a nominal document, why you gave the power to the defendant number 1 to sell the property?
Not have been done.
And also you are relying upon only the sale agreement, but the very same day you have executed the power of attorney also, that is also a registered document wherein you have given the possession even for improvement, everything. And all powers are also given to sell the property also. Now you contend that it is only a security document. That is oral evidence.
Yes. Secondly, very fact that even after the execution of that deed, I continued in possession. And the relief of injunction protect my possession, continually I am in possession, have been granted. Really, my lord, even after the execution of the deeds, obtaining the possession, not have the entries in the revenue records. Shows that plaintiff is in possession. Trial court has also found that there are documents to show that the plaintiff is in possession. You will not that deeds. Trial court has not considered.
Heard the apparent counsel. This matter is listed for admission. I heard the apparent counsel. The factual matters of case of the plaintiff before the trial court, when the relief is sought for the relief of declaration and injunction, contended that the plaintiff is the absolute owner in possession of the land bearing survey number 87/4, measuring 1 acre 23 kuntas, situated at Bettakote village of Devnalli Taluk, mentioned in the plain schedule. The plaintiff acquired the scheduled property through a sale deed dated to 12/4/1990. All the revenue record stands in his name. It is his case that in the month of February 1997, the plaintiff approached the first defendant for a loan of rupees 50,000 to his financial difficulties. The first defendant, being the money lender, had agreed to lend rupees 50,000 to the plaintiff, provided that plaintiff execute an agreement and general power of attorney in his favor with respect to the scheduled property. The first defendant assured the plaintiff that he will return the documents after the plaintiff repaid the loan amount. The plaintiff agreed to the said terms and executed an agreement of sale and also executed power of attorney in the name of the first defendant for security purpose. It is contended that market value of the property was not less than rupees 2,50,000 per acre. However, the amount shown was rupees only 50,000. The plaintiff has taken 2 years for repayment of loan amount, and hence 2 years time is stipulated in the agreement. The plaintiff repaid the loan amount of rupees 50,000 and first defendant had acknowledged the receipt of the said amount on 24/2/1999. The plaintiff insisted the first defendant to execute necessary documents and also return the agreement and power of attorney. The first defendant informed the plaintiff that he has lost those documents. On 29/7/2005, the second defendant tried to trespass into the suit shell property. On inquiry, he came to know that the first defendant, on the basis of power of attorney, had executed the sale deed in favor of the defendant number 2 on 3/3/2005. The defendant number 1 has no right to execute the sale deed in favor of defendant number 2. The plaintiff never handed over the possession of the scheduled property to the defendants. The plaintiff has not received any consideration amount from the second defendant. There is no transaction between the plaintiff and the second defendant. It is contended that first defendant has played a fraud and executed the sale deed in favor of the second defendant. The defendants have colluded and created the sale deed to deprive the right of the plaintiff. In pursuance of the suit filed by the plaintiff, notice was ordered, and defendant appeared through counsel and filed a written statement contending that the averments made in the plaint are all false, and also denied the owner in possession of the suit property by the plaintiff. The defendants are also denied with regard to the allegation of trespassing the land of the plaintiff. The trial court, based on the pleadings of the parties, made a total 10 issues. The plaintiff, in order to prove the case, examined himself as PW1 and also examined 2 witnesses as PW2 and 3 and got marked document exhibit P1 to 28, 1 to 46. On the other hand, the second defendant has examined the power of attorney holder as DW1 and got marked the document exhibit D1 to 7. The trial court, after considering both oral and documentary evidence, comes to the conclusion that the plaintiff has not proved the case that the document is only a nominal document and only as security. Sale agreement was executed and power of attorney was executed. And also the trial court comes to the conclusion that power of attorney was executed even in order to sell the property. And accordingly, the first defendant sold the property in favor of defendant number 2. And dismissed the suit. Hence, first appeal is filed before the appellate court in RA number 15045 of 2017, questioning the dismissal of the suit, contending that the reasoning given by the trial court is erroneous, and trial court has committed an error in answering issue number 2 as negative, even though answered issue number 1 as affirmative. And also counsel would vehemently contend that issue number 3 to 5 also answered as negative and answered issue number 6 as affirmative, in coming to the conclusion that based on the GPA, defendant number 1 had executed the sale deed in favor of defendant number 2. And hence, the very approach of the trial court is erroneous. The first appellate court, and considering the grounds urged before the appellate court and also on reappreciation of the both oral and documentary evidence, rejected the application filed under Order 41 Rule 27 for answering point number 1, coming to the conclusion that the appellant cannot improve his case by examining the witnesses before the appellate court. And also the first appellate court, on formulation of point whether the trial judge was justified in holding that plaintiff has failed to prove that exhibit P6 and P7, that is sale agreement and general power of attorney, dated 24 to 1997, are nominal documents and executed as a security for loan transaction. And the said point also answered as affirmative, in coming to the conclusion that it was a clear sale transaction and not the document executed as a security for loan transaction. And reversed and comes to the conclusion that no material is found that trial court has committed an error in appreciating both oral and documentary evidence, and answer the point number 3 and 4 as negative and dismiss the appeal. And hence the present second appeal is filed by the appellant before this court. The main contention of the counsel appearing for the plaintiff appellant before the court that courts below have committed an error in that sale deed executed by the first defendant in favor of defendant number 2, dated 3/3/2005, doesn't put the defendant number 2 in possession, since the possession was not given to the first defendant. And in the sale agreement, there is a recital that possession will be delivered on the date of execution of the sale deed. And the said aspect has not been considered. The trial court also, the counsel also contend that the point for consideration of this court is whether the courts below are right in holding that plaintiff failed to prove that alleged agreement of sale and general power of attorney authorized the first defendant to sell the property which are executed as a security to the loan taken by the plaintiff. And both the courts have committed an error in dismissing the suit and confirming the same, and hence substantive question of law involved in the matter has to be framed admitting the appeal. Having heard the appellant counsel and also on perusal of material available on record, the trial court, based on the pleadings of the plaintiff and defendant, framed 10 issues, both in respect of the pleading of the plaintiff, particularly issue number 1 with regard to the ownership of the appellant, and also issue number 2 with regard to the nature of document executed by the plaintiff in favor of the defendant number 1. And also based on the pleadings of the defendant, issue number 6 was framed, whether the defendant number 2 proved that plaintiff is bound by the GPA executed in favor of defendant number 1 and the sale deed dated 3/3/2005 executed by defendant number 1 in favor of the defendant confers the right in his favor. Having taken note of the material available on record, it is not in dispute with regard to the execution of the document of sale agreement and also the power of attorney. But the very contention of the plaintiff before the trial court that it was only a security document and not as an absolute sale agreement. And also the power was given to the defendant. But the fact that in terms of the power of attorney, power was given to the first defendant even to sell the property is not in dispute. But only contention that the first defendant had committed fraud on the plaintiff and sold the property in favor of defendant number 2. It is the main contention of the plaintiff appellant that it was only a loan transaction and as a security document was executed. But if it is really only a sale, not a sale transaction, it is only a loan transaction and the document was executed as security document. What made the plaintiff to give powers to the first defendant even for sell the property? It is also important to note that it is the case of the plaintiff that sale agreement was executed in the year 1997. And period mentioned is also for a period of 2 years. And it is his contention that he agreed to repay the amount within 2 years. But he contend that he also repaid the amount. Document repayment. Repaid the amount. But no document is placed before the court, before the trial court for having paid the amount what he has received in terms of the sale agreement. And the defense which was taken by him that he had repaid the amount remains as defense only. The main contention of the appellant counsel that possession was not delivered. And court has to read both the documents. No doubt in the document of sale agreement, possession was not delivered. But an undertaking was given that possession will be given at the time of executing the sale deed. And in terms of the registered agreement of sale, 50,000 amount was received as sale consideration and balance payable only 5,000 rupees. And at the same time, on the same day, power of attorney was executed in favor of the defendant number 1, wherein also the reason was given in the power of attorney that he was unable to cultivate the land. He had involved in his own work. And even for making the improvement also, he was given the powers to the agreement holder, that is defend number 1, subject to conditions. And when the recitals of the document of power of attorney is very clear that even to sell the property, the very contention of the plaintiff was not accepted by the trial court as well as the first appellate court. There is no any explanation to the giving the power even for selling the property in favor of the prospective purchaser in terms of the power of attorney. And this fact also has been appreciated by the trial court as well as the first appellate court. The first appellate court also, the trial court, particularly considering the issue number 1 to 6, taken note of the documents which have been executed, particularly in exhibit P18, paragraph number 18, discussed with regard to the exhibit P8, certified copy of the general power of attorney executed by the plaintiff in favor of the defendant. Also taken note of the document of exhibit P6. And the sale deed was executed in the year 2005 by the first defendant in favor of the second defendant, almost after 7 years of the transaction. And also in terms of the sale agreement, time is stipulated for a period of 2 years, as well as the contention of the plaintiff. And though content that he has repaid the amount, no document is placed before the court. And having taken note of this material available on record, the trial court also comes to the conclusion while answering issue number 9 that plaintiff has failed to prove that he is the owner in possession of the suit shell property as on the date of suit. However, taken note of the other documents are standing in the name of the plaintiff, that is other revenue records, and also made an observation that revenue records will not confirm any right in favor of the plaintiff. And the fact that all powers are given to the defendant number 1 even for selling the property is also not in dispute. But only contention that it was only a security document and not as the sale transaction, and the same has not been believed by the trial court. The first appellate court also, considering the grounds urged in the appeal, formulated the 4 points with regard to whether it is a sale transaction or it is only a security document, while framing point number 2. And also point number 3 is with regard to execution of sale deed by the defendant number 2 in favor of, and by the defendant number 1 in favor of the defendant number 2, and whether the judgment of the trial court requires interference. While answering these points, the first appellate court also in detail considered in paragraph number 20, that is point number 2 to 4, and considered both oral and documentary evidence available on record. And having considered the oral and documentary evidence available on record, and no doubt the trial court comes to the conclusion while answering the issue number 1 as affirmative, since the plaintiff got the property under the sale deed, and the same is also not disturbed by the first appellate court, but only the first appellate court taken note of oral and documentary evidence available on record, particularly the document of exhibit P6, 7, and 8, copy of the sale agreement, and also the copy of the sale deed and copy of the general power of attorney. And in terms of the sale agreement, the plaintiff entered into an agreement with the first defendant, and also on the very same day executed the registered power of attorney in favor of the first defendant, wherein he has given the right to the first defendant even to sell the property. Based on the said power of attorney, the first defendant executed the sale deed in favor of the second defendant. And all these materials were taken note of by the first appellate court. And on reappreciation of the material also comes to the conclusion that no error is committed by the trial court. Having considered the reasoning given by the trial court as well as the first appellate court, and also in keeping the contention urged in the second appeal by the appellant counsel, and main contention of the counsel appearing for the appellant that no possession was delivered when the possession was not delivered, the trial court as well as the first appellate court ought to have granted the relief of permanent injunction. I have already pointed out that in the sale agreement, though it is mentioned that possession will be delivered at the time of executing the sale deed, but document of power of attorney executed on the same day, the possession was given to the power of attorney holder, even for improvement of the property. And both the documents are contrary to each other. And apart from that, contents of the document exhibit P6 is very clear with regard to the receipt of the sale consideration. And also in terms of exhibit P8, power of attorney, the power was given to the power of attorney holder to execute the sale deed. And when such right was given under the registered document in favor of the defendant number 1, and accordingly defendant number 1 executed the sale deed in favor of defendant number 2, even after lapse of 7 years of entering into the sale agreement. Since sale agreement was of the year 1997 and sale deed was executed in the year 2005 by the defendant number 1 in favor of the defendant number 2. And when such material found, the very contention of the appellant counsel that both the courts have committed an error and this court has to frame the substantive question of law cannot be accepted. I do not find any perversity in the finding of the trial court as well as the appellate court and question. And in order to invoke section 100, I do not find any ground. And hence, the appeal, second appeal is liable to be dismissed. In view of the discussions made above, I pass the following order. This discussion.
21, my lord. 21, I am for the respondent. 21.1 I am for the appellant. ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಉಂಟು ಮಾಡೋದು ಜಾಸ್ತಿ ಇಲ್ಲ, ಅದನ್ನ ನಾನು ಕಂಪ್ಲೈ ಮಾಡ್ತೇನೆ. ಇಟ್ ಮೇ ಬಿ ಟೇಕನ್ ಆನ್ 30th my lord. ಸ್ವಲ್ಪ ಇರುತ್ತೆ, ಮೈನರ್ ಇರುತ್ತೆ.
ಹಾಕಿಲ್ಲ ನೋಡಿ. The appellant counsel in RSA 1553 of 22(6) ಎಷ್ಟು ದಿವಸ ಬೇಕು?
30th ಗೆ ಹಾಕೊಳ್ಳಿ ಸರ್. ನಾನು ನಾಳೆ ನಾಡಿದೆ ಕಂಪ್ಲೈ ಮಾಡಿ, ಏನು ಮೈನರ್ ಇರೋದು ಅದು.
And counsel 31 ಆಯ್ತು. Seeks 2 days time to comply with office objection, and counsel appearing for the respondent R1 to 3 also seeks time to file wakalat on behalf of R1 to 3. And hence list the matter 31st.
30th ಗೆ 31st ಗೆ ನಾನು ಸ್ವಲ್ಪ ಔಟ್ಸೈಡ್ ಹೋಗ್ತಾ ಇದ್ದೇನೆ.
ಅವ್ರಿಗೆ 31st ಬೇಕಂತೆ, ನಿಮಗೆ 30th ಬೇಕಂತೆ. ಯಾವ್ದಾರು ಬೇರೆ ದಿವಸ ಆಗ್ಬೋದಾ ಹೇಳಿ? 27th ಆಗ್ಬೋದಾ?
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು. 30th ಇದ್ರೆ ಒಳ್ಳೇದಿತ್ತು ಅಲ್ಲ, ಅವರಿಗೆ ಆಗುದಿಲ್ಲ ಅಂತ.
ಆಗ್ಬೋದಾ? ಆಯ್ತು 30th.
ಅಪ್ಲೈ ಸ್ವಾಮಿ.
ಆಯ್ತು 30th ಹೇಳಿ ಅಂತ. ರಾವೇಂದ್ರ ಕಾಮತ್. ಆಫೀಸ್ ನೋಟ್ ಇದ್ರೆ ನೇಮ್ ಆಫ್ R1B ಅಂತಿದೆ.
ನಾನು ಕರೆಕ್ಟ್ ಹೆಸರು ಹಾಕಿದ್ದೇನೆ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. ಅವ್ರು ಸ್ವಲ್ಪ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ, ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಹೆಸರು ಹಾಕಿದ್ದಾರೆ.
ಬರ್ಕೊಡಿ ಈಗಲೇ. ಕೌನ್ಸಿಲ್ has filed and the counsel in appeal RSA 4246 of 21 submits that while arraying the legal heir of respondent number 1 D, name is mentioned as Raghavendra Prasad instead of Raghavendra Kamath, and hence he may be permitted to correct the same. The counsel appearing for the respondent also submits that he has correctly mentioned the name as Raghavendra Kamath in other connected appeal. And having taken note of the said submission, the appellant counsel is permitted to correct the same as Raghavendra Kamath instead of Raghavendra Prasad. ಒಂದು ಮೆಮೊ ಕೊಡಿ, ಅದರ ಮೇಲೆ ಕರೆಕ್ಟ್ ಮಾಡಿ.
30 ಸ್ವಾಮಿ.
30.
ಅಪ್ಲೈ
MJ ಆಳ್ವಾ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಪಾರ್ಟ್ ಹಾಡಿತ್ತು, ಏನಕ್ಕೂ ಡೆಫರ್ ಮಾಡಿದ್ವಿ. ಹ್ಮ್ 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 ಇನ್ನೂ ಒಂದು ವಾರ ಬೇಕಾ? ಹ್ಮ್ 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 ಹ್ಮ್
Dependents had filed.
ಹ್ಮ್ ಹ್ಮ್ ಅಪಲೇಟ್ ಕೊಡು. Appellant counsel again 6 1 week time. List this matter on ಯಾವತ್ತು? 27th 1 week 27th. ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಎನ್. ಯಾವ್ದು ಹೇಳಿ? 23 ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ವಲ್ರಿ ನಿಮ್ಗೇನ? But he has undertaken that he would inform you. Has he informed you or not? ನೋಡಿ ಹಿಂಗಾಗುತ್ತೆ. ಅಡ್ವೊಕೇಟ್ಸ್ ಇಲ್ಲ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ನಾ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀನಿ. ಕೋರ್ಟ್ ಒಳಗಿರೋರಿಗೆ ಒಂದು ಸಫಿಷಿಯಂಟ್. 6th February ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವತ್ತು ಇಯರ್ ಮಾಡಿ 6th February. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದೆ. ಅದಕ್ಕೋಸ್ಕರ ರೀಚ್ ಆಗೋದಿಲ್ಲ. ಸುಮ್ಮನೆ ಕೊನೆಗೆ ಅರ್ಜೆಂಟ್ ಮಾಡೋದು ಬೇಡ ಅಂತ. 6th February ಟೇಕ್ ಅಪ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಇವನ್ ನಾನು ಆಕ್ಚುಲಿ ನೋಟು ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಪ್ರೇಸ್ ಟೈಮ್ ಅಂತ. ಏನೋ ಸಮ್ ರೀಸನ್ಸ್ ಹಿ ಹ್ಯಾಸ್ ಗಿವನ್. 24 ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಎನ್. ಡಿಕ್ರೀಡ್ ಇನ್ ಪಾರ್ಟ್. ಅದರ್ ಐಟಮ್ಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಕನ್ಫರ್ಮ್ಡ್ ಇನ್ ಅಪೀಲ್. ಇಲ್ವಾ? ಪಾಸ್ ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಅರ್ಜೆಂಟ್ 26 ಶಿವರಾಮ್ ಹೆಚ್.ಸಿ. ಎಸ್ ಮೇಡಮ್. No, madam. Last time also prayed time. Call ಬರ್ತದೆ, ದಿನ ಬರ್ತದೆ ಕಾಲ್. You argue assist the court. Decreed for 18,000. Appeal reversed. So it is dismissed. Divergent finding. 1 second. 15,000 ಕೊಟ್ಟು ಸೇಲ್ ಡೀಡ್ ತಗೊಳ್ಳಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಇದರಲ್ಲಿ get the registered sale deed in his name. Appeal very plaint itself is dismissed. Issue emergent note against respondents. This matter on the other on date kodi madam. Up to 1 month kodi. 22nd of February na. 20th of February. Right. J. Kirti MC.
Appear for appellant counsel, my lord. Kindly pass over the matter, my lord. Senior father is not feeling well. Taken to the hospital. Kindly pass over the matter, my lord.
Pass over ಮಾಡೋಣ. ಕೇಳ್ತಾವ್ರ ಪಾಸ್ ಓವರ್. ಫಾದರ್ಗೆ ಏನೋ ಕರ್ಕೊಂಡು ಹೋಗಿದಾರಂತ. ಆಯ್ತ್ರಿ, ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ. Declared as owner, that has been confirmed by the appellate court.
We are ready, my lord.
ರೆಡಿ ಅಂತ. ಪಾಸ್ ಓವರ್.
Much obliged, my lord.
Delay of 1,279 days. Not aware in the sense? Other side are in appellant and LRs of deceased R2. Judgment ಆಗಿರೋದು ಯಾವಾಗ? 16. ಕೋವಿಡ್ ಬಂದಿದ್ದು 4 ವರ್ಷದ ಮೇಲೆ. Whether he has represented through counsel or not. Hmm. Hmm. Now he contend, how he can contend that it was not in his knowledge. Appeal was filed in which year? Court of the year 2006. The same was decreed for the relief of specific performance. ಎಷ್ಟು amount sale consideration? Sale consideration ಎಷ್ಟು? 2,50,000. ಏನ್ ಲ್ಯಾಂಡ್ ಆಯ್ತು. ಹ್ಮ್.
1,88,000.
ಹ್ಮ್.
Second difference.
Item 1 to 3 are hereby directed to execute sale deed duly converting, conveying the property in terms of agreement dated 3/2000 by receiving the balance in consideration. So.
Proving readiness and weakness. End of the judgment of the trial, documents filed. None of the documents show any documents showing any amount that the apart from
First, ಹೋಗಿ application ಹೋಗಿ condonation of delay. Then we will consider matter on merits. 1,472 days is not a liberally. Apex court recently held even for 300 days of delay, dismissed the appeal. Don't say nailed first.
not have the money either to pay the court fee or to engage in lawyer. And by the time he accumulated that COVID.
Affidavit ಓದಿರಿ, affidavit ಓದಿ ಹಿಂದೆ. Passed by the first appellate court in the year 2016.
Contact. I received the notice. To execute the daily in the execute to agency of law. Thereafter, immediate manner after collecting necessary payment to engage further. Hence, there is delay. I submit that after COVID and during.
ಯಾವಾಗ ನಿಮಗೆ ನೋಟಿಸ್ ಬಂದಿರೋದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ?
2017.
ಮತ್ತೆ 17 ನೀವು ಫೈಲ್ ಮಾಡಿದ ಯಾವಾಗ ಅಪೀಲ್? 22. ಮತ್ತೆ even he had the knowledge in 2017 itself. ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಡ್ಯೂ ಟು ಇಲಿಟ್ರಸಿ. Not a case for even after 6 years this appeal is filed. It was confirmed in 2016 itself. We have to show the sufficient cause. What is the sufficient cause? What is the sufficient cause? It is the only ground. Third, no ground. Condone the delay of 1,279 days. Better affidavit ಹಾಕಿದ್ರು ಉಪಯೋಗ ಇಲ್ಲ. ಏನಾಗುತ್ತೆ ಇಲ್ಲಿ? Appeal was disposed of in 2016 and present appeal is filed in 2022. Land ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. He kept quiet and also he slept over the judgment. Even appeal filed by him only. How he can contend that he was not aware of the same? Even assuming that he was not aware of the same of disposal, but he comes to know about the same in 2017 itself. After 2017 also, he filed appeal in 22. ಲಾ ಕ್ಲರ್ಕ್ ಇದಾರೇನ್ರಿ 2022 ನಲ್ಲಿ ಜಸ್ಟಿಸ್ ನಾಗರತ್ನ ಮೇಡಮ್ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ 22 ನಲ್ಲಿ ಇವನ್ ಡಿಲೇ ಆಫ್ 400 days ವಾಸ್ ನಾಟ್ ಕಂಡೋನ್ಡ್. Not a case for no sufficient cause. That is not a ground. That is not a ground. That is not a ground. ಇದರ ಇಲ್ವಾ? ನಾನು ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡುವಾಗ ಒಂದು ಅದನ್ನ ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿ ಮಾಡಿದ್ದೀನಿ. ದೇಶದಲ್ಲೆಲ್ಲ ಇರೋರೆಲ್ಲ ಪೂರ್ವ ಇಲಿಟ್ರೇಟ್ ಎಲ್ಲ ಅವರೇನೆ. That is not a ground. That is not a ground. In your affidavit itself, you have stated that it had come to your knowledge in the year 2017 itself, but you have filed the appeal in 2022. After lapse of 5 years. No.
He has also stated.
That is not a ground. That is not a ground. Then what is the remedy for him if he is unable to pay the court fee? Merits here, madam. First you convince the court with regard to the delay is concerned. Affidavit ಹಾಕಿರೋ ಉಪಯೋಗ ಇಲ್ರಿ. ಏನ್ affidavit ಹಾಕಿದ್ರು ಅಷ್ಟೇನೆ, it will not improve. Your own admitted fact in the affidavit itself that what is there? RSA 354 of 22. This bill is listed for admission along with IA to condone the delay of 1,279 days in filing the appeal. For the appellant counsel. And counsel would submit that due to his illiteracy and also the appellant is an auto driver and he was not having financial facility. What is there to decide? ಯಾವ ಸಿಚುವೇಶನ್ ಅಷ್ಟೇ. ಆಯ್ತು, ದಿಸ್ ಮ್ಯಾಟರ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ತೀವಿ ಮೇಡಮ್. ಟ್ಯೂಸ್ಡೇ 24. ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತೆಗೆದಿಡಕ್ಕೆ ಹೇಳಿ ಮೇಡಮ್. ನೀರ ಹೇಳ್ರಿ. ಪಾಸ್ ಓವರ್ ಏಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ? ಆಯ್ತು, ಪಾಸ್ ಓವರ್ 30. Trial court comes to the conclusion that rectification deed is null and void. ಹೌದಾ? Confirmed in the appellate court. Suit for only for bare injunction. Then bare injunction is maintainable without.
the correct. And along with my PA for they have ended of the training. Even in the sketch and depends in the schedule. Two items. One. In the case of the that deeper application deed. Right? There was a change in the they are saying the along we have disputed the title of the right of that we have been getting advantage of this. But two appeals filed against the judgment, one appeal by the two and one appeal by the
separately. Number ಯಾವ್ದು? RSA number ಯಾವ್ದ್ರಿ? Five 510 arising out of the same judgment. Two regular appeals. Regular appeal RSA ಏನ್ರಿ? ಅದು ಬೇರೆ ಬೇರೆನೆ ಮಾಡಿದಾರ? Questioning the judgment and decree in OS number 36 of 2011. Why separate judgment, separate appeals? The other RSA is also challenging the regular appeal number 2 of 2019 or different RA, but arising out of OS number 36 of 2011. Common. Toli madam. Already ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ RSA ನಲ್ಲಿ ಬಂದಿಲ್ವಾ? ಎರಡನ್ನು ತಗೊಳ್ಳೋಣ, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ಅದಕ್ಕೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. The counsel appearing to the appellant would submit that arising out of the judgment and decree passed in OS number 36 of 2011, both the first defendant and second defendant have filed the separate RAs and RA number 2 of 2019. Innan number eno? And RA 1 of 2019. Both the appeals are dismissed. Houdalla? Being agreed by both the judgment and decree passed in RA 1 of 2019 and 2 of 2019. There are two RSAs. And other RSA is RSA number 1510 of 22. And hence registry is directed to post the RSA 1510 of 22 along with this appeal. On Yawat Beck. 27th. 27th. Adi Narayanappa. Okay. Decree ಆಯ್ತು, ರಿವರ್ಸ್ ಆಯ್ತು. On the ground that applies res judicata ಅಂತ. Right. Appellant counsel seeks one more week time to produce the copy of the plaint res judicata apply ಆಗುತ್ತಾ ಇಲ್ಲ ಅಂತ ನೋಡಕ್ಕೋಸ್ಕರ ಮೋಸ್ಟ್ಲಿ ಹೇಳಿದ್ದೆ ಅನ್ಸುತ್ತೆ. ಯಾವಾಗ ಬೇಕು ಅದು ತಗೊಳ್ಳಿ. Appellant counsel again seeks 1 week time. This matter on 31st. Swami. Ilva? Pass over. Directed you to have hand over the vacant position. Jay Kirti.
Serial number
No, Jay-
30. Kindly pass over. Kindly pass.
33.
Yes, my lord. Kindly pass over, my lord.
ಆಯ್ತು ಅವ್ರೇನೋ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಾ ಇದಾರೆ ಹಿಡಿದು ಹಿಯರ್ ಮಾಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ. ಓಕೆ ಎಲ್ಲ ಬಹುದು ಎಷ್ಟು ಸರಿ ಓದೋದ್ರಿ ನಾವು ನೋಡಿ. Appellant counsel present and respondent counsel seeks pass over and counsel appearing to the appellant submits that he has got inconvenience in the afternoon and hence this matter on 27.
Oblige, my lord.
Stay ಇದೆಯಾ? Interim order ಇದೆಯಾ? Interim order granted is extended. ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ till next date of hearing. ಹೇಳಿ ಮೇಡಮ್.
Oblige, my lord.
34 Vishwanath K. No, counsel, last time also you took time. ಬರೀ ಎಲ್ಲ ಇವತ್ತು ಬೆಳಗ್ಗೆಯಿಂದ ನೋಡಿ ಒಂದೇ ಡಿಸ್ಕಸ್ ಮಾಡಿರೋದು. ಏನಾಗಲ್ಲ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನಾಗ್ತದೆ ನೀವು ಒಬ್ಬರೇ ಇರಾಗ 117 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಏನಿದೆ ಗ್ರೌಂಡ್ ಹೇಳಿ. ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್. ಮತ್ತೆ ಎಷ್ಟು ವರ್ಷ ಕಾಯ್ಬೇಕ್ರಿ ಒಂದು ಶೇರ್ಗೆ? ಅವ್ರ ಮಕ್ಳು ಬರ್ಬೇಕ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಮತ್ತೆ 2014 ವಾಟ್ ಈಸ್ ದಿ ಎರರ್? ಮತ್ತೆ ನೋ ಎರರ್ ಅಂದ್ರೆ ನೋ ಸೆಕೆಂಡ್ ಅಪೀಲ್. ಆಯ್ತು. ಮತ್ತೆ 17 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಸ್ ದೇರ್ ಎನಿ ಎರರ್ ಇನ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಫ್ ದಿ ಶೇರ್? ಹೇಳಿ, ಅದನ್ನ ಸರಿ ಮಾಡೋಣ. ಇಲ್ಲ ಎರರ್ ಏನಿಲ್ಲ. ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ನೋಡಿ. Heard the appellant counsel. They told him this matter is listed for admission and heard the appellant counsel. The factual matters of case of plaintiffs before the trial court while seeking the relief of partition and separate possession and mean profits. It is their contention that Putta Honnappa and his wife Kempamma are having 4 sons and 3 daughters. And the Putta Honnappa during his lifetime was managing the suitable property. The same are ancestral joint family properties of plaintiffs and defendants. And hence they are entitled for 1/7 share in the suitable properties. The defendant, in pursuance of the suit summons, appeared and filed the written statement, stating that item number 3, property is the self-accord property of defendant number 8. The defendant number 1 took the contention that suit item number 2, property is the self-accord property of defendant number 1, father of defendant number 2 to 5. The plaintiff, in order to prove the case, examined herself as PW1 and got marked the document of exhibit B1 to 5, that is RTC extracts and Kata extracts. On the other hand, the defendant number 7 examined himself as DW1, got marked document exhibit D1 to D9. The trial court, after considering both oral and documentary evidence, answered the issue number 1 as affirmative in coming to the conclusion that suitable properties are the ancestral properties. It also comes to the conclusion that Item number 3 of the property is the self-acquired property of dependent number 8. And also item number 2 is the self-acquired property of husband of dependent number 1. Husband one bit number 1 as affirmative. Trial court will considering issue number 2 and also issue number 5 answered the point partly in the affirmative in granting share of 1/7 share each in suitable property item number 1 and also granted share in favor of accused defendant number 6, 7 and 9 that they are also entitled for 1/7 share in respect of item number 1 of the suitable property. It is also held that defendant number 1 to 5 together are entitled for 1/7 share in the suitable item number 1. In respect of item number 2 and 3 is dismissed. Being agreed by the judgment and decree, the error appeal the 6th defendant and 9th defendant have filed the appeal, and the same is numbered as RA number 79 of 2019. The first appellate court considering the grounds urged in the appeal and also on reappreciation of evidence available on record dismiss the appeal and confirm the judgment and decree of the trial court. As the present RSA is filed. The main contention of the counsel appearing for the appellant before this court is that the courts have not given proper opportunity to the appellants to lead their evidence. Without considering the proper evidence on record, trial court has granting the relief. And also the finding given by the first appellate court also erroneous and committed an error. Having heard the appellant counsel and also on perusal of material, no dispute with regard to the relationship between the parties. Though the plaintiffs have made the claim in the original suit in OS number 14 of 2014, claiming share in respect of all the suit properties, the trial court as well as the first appellate court comes to the conclusion that they are entitled for share only in respect of item number 1 of the suit property. And also given definite finding with regard to item number 2 and 3 as self-acquired properties of husband of dependent number 1 and also the dependent number 8. And the same has not been questioned and challenged by the plaintiffs. And only the appellant herein only challenged the same. And in order to come to other conclusion, the trial court having taken note of the evidence of PW1 and also the evidence of DW1 in paragraph number 18 to 20 discussed with regard to the defense of the defendants, particularly in respect of item number 1 of the property. Income derived from the property was not sufficient to provide 2 square meal a day to the family members. And the admission given by PW1 also extracted in paragraph number 18 and 19. Also taken note of the admission given by defendant admitted and admission given by the PW1 And also taking note of dependent number 7 who is working as a driver in KSRTC by raising loan from his department has purchased the suit item number 3 property constructed a house. So also in respect of the other item of the property. And also while answering issue number 5 comes to the conclusion that there is no dispute regarding allotting 1/7 share of each of the plaintiffs. And having perused the material available on record, the trial court rightly comes to the conclusion that the plaintiffs are not entitled for any relief in respect of item number 2 and 3, except the item number 1 of the social property. The first appellate court also on reappreciation of both oral and documentary evidence, particularly answering point number 1 to 3, which are formulated by the appellate court. And appellate court comes to the conclusion that judgment and decree passed by the trial court in respect of item number 1, that is based on material and record, and also taken note of documents of exhibit P1 to 3, which are the RTC extracts, and exhibit P4 and 5 are the Kata extract. Paragraph number 21. Reason was also given, and also taken note of the evidence placed by the defendants. And in paragraph number 22, 23. Take a note of the death of Kempamma, and also considering Section 15 of Hindu Succession Act 1956. And extracted the admission given by PW1, paragraph number 23. Considering the matter based on the oral and documentary evidence, and confirm the judgment. Though counsel appearing for the appellant vehemently contend that both the courts have committed an error, I do not find any perversity in the finding of the trial court in coming to the conclusion that plaintiffs are entitled here in respect of item 1 of the social property, which are the ancestral property. And also appellate court also, having reappreciated the material available on record, comes to the conclusion that the plaintiffs are entitled for share in the suit schedule property. Plaintiff and other defendants are also entitled for share. Hence, I do not find any grounds to admit the appeal and have any substantive question of law. PC Venkatesh. Paso. Breaker LS.
That there was an earlier round of litigation for permanent injunction, and the suit was influenced on the basis of a commissioner report, wherein the very existence of the legal property was doubted by the court commission. The appellate court also is on the same. For a moment, your lordship may kindly look into the additional documents for this one. It is the appeal which was filed against the suit judgment in the suit for permanent injunction. The appellate court declares the suit of the permanent injunction. This particular judgment was not placed before both the courts below because the natives were not in knowledge of the appeal. The defendant was probably having knowledge about filing the also have been having knowledge of the reversal of the judgment in the permanent injunction suit. He suppressed it before the trial. The
Earlier it was dismissed and in the appeal it was decreed. That is in respect of the property,
same suit schedule property.
same suit schedule property.
Yes.
Ah.
That suit was for permanent injunction. This suit is for declaration. That earlier suit, court commissioner says that on the basis of the
Now this is the suit for declaration and injunction.
oh, but the courts again rely on the same judgment and the commissioner's report in the referred in the earlier judgment and dismissed the present suit. In the present case, the defendants
RA judgment was not placed before the trial court. Why?
because it was of the suit itself was not in the
Earlier.
appearance of the defendant. When he takes up a contention, they amended the plaint and they brought the amendments in the plaint. But regarding the filing of the appeal by their father, they were not having the knowledge.
You are claiming the ownership based on
On the basis of two sale deeds.
sale deeds.
Defendant's claim is that there is no scheduled property. The property which I am claiming is not in existence. We are making a claim against a property which was allotted to them by the government. They did not produce, they did not enter into the witness box in the present. They did not produce any documents. There is the site number 8 in existence. Only on the basis of the earlier judgment, the suit came to be.
Whether the defendant proves that the suit is hit by principles of res judicata by virtue of OS number 300. What is that? But you have not proved the case anta nimdu. You have not proved the ownership in respect of the social property. That is the finding of the trial. Sale deed boundary.
Is mentioned in the appellate court judgment. Page 14.
Page 14. Ink page 29. Used by Koracha Somappa.
Appellate court says that the discussion part compares the in page 35, para 24. Under the serious dispute of boundaries. Property as mentioned in the topic which dedicated also. It's been and it's been as polar related to size mark is so and so number dinanka so and so ಆಗಿರುವ ಕಾರಣವು ಪೈಕಿ ವೆಂಕಟರಾಮ ಅವರಿಗೆ ಮಂಜೂರು ಆಗಿರುವ 6 ಹುಣಸೆಮರಗಳ ಪೈಕಿ ಬೇರೆ ವೀರಾಪುರ ರಾಮನಂತ ಪೈಕಿ ಒಂದು ಹುಣಸೆಮರಕ್ಕೆ ಬಂದು ಕೊರಚರ ವೆಂಕಟಸ್ವಾಮಿ ಜಮೀನು ಪಶ್ಚಿಮ ಉತ್ತರ ಮತ್ತು ದಕ್ಷಿಣಕ್ಕೆ ನಮ್ಮ ಪೈಕಿ ಬಲಂತಿ ವೆಂಕಟರಾಮ ಈ ಮಧ್ಯೆಯೂ sale deed dated 73 and exhibit PI containing the property description as ಕೋಲಾರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ವೀರಾಪುರ ಸ್ವಾಮಿಯವರಿಂದ ನನ್ನ ಹೆಸರಿಗೆ ನೇರವಾಗಿ ನನಗೆ
Boundaries mentioned in the year 1959 document and also in the year 1979 under which you have purchased the property, they are not tallies with each other. That is the finding of. Hmm. Hmm.
Solely on the basis of the Panchayat Act. Panchayat records, whatever the boundaries are mentioned.
Hmm.
The trial court is of a different opinion there. The dimension mentioned in the JDF is 11 yards by 11 yards. Whereas in the plane it is mentioned as 33 by 33 feet. 33 feet by 33 feet. 11 yards. There will be development in the area. But regarding the entire, both the courts are relying only on the judgment on the suit for permanent which has been reversed. The reason there for the suit earlier was the court commissioner. The very court commissioner report, the appellate court is declaring the suit.
Document you have produced, issue notice. Emergent notice. Against the respondent. 37. ದರ್ಜನ ಆಯ್ತಾ ಯಾರು ಪಾಸ್ ಓವರ್ ಯಾರು ಇದ್ದಾರಾ ಪಾಸ್ ಓವರ್ ಯಾರು ಇದ್ದೀರಾ 32 ಹೇಳಿ ಸ್ವಾಮಿ ಪರವಾಗಿಲ್ಲ ಏನು ತೊಂದರೆ ಇಲ್ಲ ಹೇಳಿ decreed for 625th share and 125th share modified 620 120 appeal by different number 1 ಹೌದಾ 1 and 2
They claim that they have the daughters of
first wife
they claim that she is the first wife.
or she claims first wife right
And the second appellant is daughter first. Number 1. Number 1.
mother and daughter
The trial court plan, after considering that motion partition of the body, partition of the daughters are entitled equal share of the ಅದರಲ್ಲಿ and granted limited share to the appellant. First appellate court plan, after considering that the section 16(3) clause 3 of the Indian Marriage Act, and they are illegitimate child, they are not entitled equal share of caste. Third, the same, but to the larger picture.
Is there any issue with regard to whether this is a property of ancestral property or
Admitted is the property another thing.
what is the claim of the plaintiff number 1, whether she is the first wife or second wife?
She first wife. Both the court held that she is the second wife. Married during the
Subsistence of first marriage.
The second issue that what happened, the Guru Swami, the husband of first appellant, he died in the year 2015. That is much before the act. The act makes you Guru Swami becomes the other property. Second, Strongly, here that she is not entitled. That way, the judgment and decree, call for interference. And another thing, the Guru Swami, the husband of first appellant, during his lifetime, he executed
Will dated 23/7/1984 anta.
The trial court as well as the first appellate court, plaintiffs. The properties, the first wife, the mother of plaintiffs, not she went out for matrimony of 80s. She filed a maintenance petition before 1981, and not there was an execution petition that was filed for maintenance. So thereafter, they said Purushon not married the appellant number 1. And since 1970, admitted not since 1981, they were living together, and she was taking care of the husband. So he executed will. So there is no such suspicion for executing the will. Now, one thing. Number 2 thing, in order to do the execute will, one DWD has an exam. It has that, in the chief examination, he admitted the registered will. Registered will. He says that he is admitted that the Guru Swami is executed will in my presence and other. And in the cross examination, at the instigation of PW's husband, who is the uncle of the defendant, he say contrary to the chief cross examination. Registered will. Another thing, in the will, the Guru Swami ಕೆಲವು ಪ್ರಾಪರ್ಟೀಸ್ ಗಳೆಲ್ಲ ಹ್ಯಾಡ್ ಮಾಡ್ಕೊಂಡು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಫ್ಟರ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದ ವಿಲ್, ದಿ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇನ್ಕ್ಲೂಡೆಡ್ few properties which is in the will, but they cleverly not included one house which is allotted to the Guru Swami in the earlier partition. The will is there. They are not included in the total property because the Basavana ಅವ್ರಿಗೆ ಪ್ರಾಪರ್ಟಿ ಸೇರಿದೆ ಅಂತ ಹೇಳಿ ಆ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ. ಸೊ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಷಿಯಲ್ ಪಾರ್ಟಿಷನ್ ಇಸ್ ನಾಟ್ ಇನ್ಕ್ಲೂಡೆಡ್.
ಆ ಪ್ರಾಪರ್ಟಿ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಹಾಕಿದಿರ ನೀವು?
ಏನ್ ಹೇಳಿದೀವಿ ಆ ಪ್ರಾಪರ್ಟಿಗಳೆಲ್ಲ ಅವರು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ.
But concurrent finding was given that will was not proven.
The contrary evidence given.
The evidence was not accepted. Automatically they are entitled for share, you know.
But in the both the court in view of provision 16(3), the property, all the properties are unrestricted property, and it is not entered equal share anta madidare. They gave a share to the motion partition madidare. ಆ share ಅಲ್ಲಿ ಮಾತ್ರ ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. This is bad in law. Because the admitted the Guru Swami died in 1923, so it is much before the act came into force. The absence of main issue, the property, even if it is self-accord properties of Guru Swami, it is all the properties are become the self-accord properties of Guru Swami. The second appellant, even if it is illegitimate child, she is entitled in question. The court the trial court ಅಲ್ಲಿ first appellate court ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪೇಂಟಿಂಗ್ ಆಗಿರೋದ್ರ ಬಗ್ಗೆ plaintiffs have filed cross appeal. In the cross appeal, share ಅನ್ನ diminish ಮಾಡಿದ್ದಾರೆ. Another bill in RSM number 49. Due to file which is pending. Of the judgment, first of all, 15. In view of the said judgment, the Honorable Supreme Court, plaintiff 123 and later the father of father entitled 1/4 share in the social property. Further, the evidence placed before the trial court clearly reveals that the mother of the plaintiff and late Sri M. Guruswamy living separately during the lifetime of their father. The plaintiff formed and there is a co-personal dispute are pending before them. In this regard, the late M. Guruswamy living with the first defendant and he has got a female child who is none other than the second defendant. In the second defendant is the daughter of late M. Guruswamy entitled to the share in the share of late M. Guruswamy, the 4/1/4 share, which is bad in the property, even if it is considered as a separate property. So, on the absence of male issue, because he died before the act, cannot be self-acquired property. So, this finding is contrary to law. And even if it is treated as an ancestral property, so the judgment cannot the annual report year 111.
This third defendant is also a daughter. Defendant number 3. Mortgager.
Is now vacated.
Only now remaining is only 5. Plaintiff number 3, 1 to 3. Defendant number 1 and 2, mother and daughter.
Ceremony. The daughter, even if it is individual matter, is entered in the court.
Right. So, issue notice. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ? 17 ಏನಕ್ಕೆ? ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್. ಆಯ್ತು, ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ಅದು ಮಾಡೋಣ, ಅವ್ರು ಬರ್ಲಿ ನೋಡಿ. ಇಶ್ಯೂ ನೋಟಿಸ್, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವಾಗಿದೆ? 7th of February. This matter on 6th on IA only 55 days alva. On IA ನೋಡಿ issue notice on main and also on IA. Consider ಮಾಡ್ತೀವ್ರಿ. Before that date I have given fix the date. ಇನ್ನೊಂದು RSA ಇದೆ. ಮೊದಲೇ ಹೇಳ್ಬೇಕಿತ್ತಲ್ರಿ ಅದನ್ನ. ಅವ್ರು ಹಾಕಿರೋದ? ನೀವೇ ಹಾಕಿದ್ದೀರಾ? ತಗೊಳ್ಳಿ. The register is also directed to post RSA number 1749 of 22 along with this appeal. Remaining matters at 240. ಹೇಳಿ. Number 2 na. ಏನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇವಲ್ಲ 6/2 ಸಫಿಶಿಯಂಟ್. ನೀವು ಇರ್ಲಿಲ್ವ ಅವಾಗ? ನೋಡಿ ಮೇಡಮ್, ಯಾರು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡ್ರೆ ಹೇಳ್ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಹ್ಮ್
They never come. They have, by mistake, my lord, they have listed the matter before my lordship. This fresh application.
ಮುಂದೆ ಬಂದಿಲ್ಲ. But why it is posted before? ನೋಡಿದ್ರಾ? ಬೇರೆಯವ್ರು ಬಂದಿದ್ದಾರೆ. ನಮ್ಮ ಮುಂದೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆಯವ್ರದ್ದು ಅಲ್ಲ ಆಗಿದ್ದು ನಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ. 4 quotations dispose ಆಗಿದೆ. This accused does not. ಅಲ್ಲ ಕಳ್ಸಿ ರೋಸ್ಟರ್ ಬೆಂಚ್. ನೋಡಿ. It is noticed that the matter was not come up before this court earlier. It appears by mistake. Posted before this court and hence post the matter before the roster bench. First time. It is directed to take notice and file objections if any next Wednesday. Date today. 25th. This true none. ಮಾಡಿಲ್ಲ. 1 and 2. 1 and 2. ಇವತ್ತು ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಇದು? ಡಿಸ್ಮಿಸಲ್ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇದೆ ಮೇಡಮ್. ಏನ್ ಕರೆಕ್ಷನ್? ಏನ್ ಕರೆಕ್ಷನ್? Madam, time was given to comply within specific date. Do not comply. ಈಗ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Already there is an order for dismissal. Earlier order ಕೊಡಿ. ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿಲ್ವಾ? ನೋಡಿ. This matter was listed on 4/1/23. And counsel sought 2 weeks time to comply with office objections. I think ಮುಂಚೆ matter was listed on 4/1/23. Although 2 weeks time was granted to comply with office objections, the office objections are not complied. And this court also noted that even though matter is listed for second time for non-compliance of office objections, till date office objections are not complied. However, to meet the ends of justice, again 2 weeks time was granted for compliance of office objections. The order also, it is also made it clear that if office objections are not complied within 2 weeks, list the matter for dismissal on 19/1/2000. List the matter today for dismissal, and counsel would submit that 2 office objections are not complied. When the time was given to comply with office objections, the same is not complied. And hence, as per the order dated 4/1/2023, appeal is dismissed for non-compliance of office objections. Comply ಮಾಡಿ. ಕರೆಕ್ಷನ್ಸ್ ಅದೇನೆ ಮೇಡಮ್, ಅದಕ್ಕೇನೆ. ಯಾವ ವರ್ಷದ್ದು ಅಪೀಲ್? ಯಾವ ವರ್ಷದ್ದು? 2020. ಆರ್ ಇನ್ 23. ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿದಾಗಿದೆ ಮೇಡಮ್. ಇಲ್ಲ, ಅರ್ಲಿಯರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿ. ಮೊದಲಿದ್ದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮೇಡಮ್. 2020 ಅಲ್ಲಿ ಹಾಕಿ 2020 ಅಲ್ಲಿ ಹಾಕಿರೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಆಯ್ತು, ಮಾಡಿ ಒಂದು ಅರ್ಜಿ ಹಾಕೊಳ್ಳಿ, ಆಮೇಲೆ ನೋಡಿ. ನಂಬರ್ 15. ಹೇಳಿ ಕೌನ್ಸಲ್. ಅಲ್ರಿ ಪ್ರತಿ ಸಾರಿ ಟೈಮ್ ಕೇಳ್ರಿ ಹೇಗ್ರಿ ಅಡ್ಮಿಷನ್ ಬಂದಾಗ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಟೈಮ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಹೌದಾ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಹಾ ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೈಂಟ್ 6 ಟೈಮ್ ಹೆಸರು ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಫೈನಲ್ ಇಯರಿಂಗ್. ಹಾ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೈಂಟ್ ಪ್ರೇಸ್ ಟೈಮ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್ ಅದಕ್ಕಿಂತ ಅರ್ಲಿಯರ್ ಹೆಸರು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕ್ರಿ ಅಡ್ಮಿಷನ್ಗೆ. ಕಂಪ್ಲೈನ್ಸ್ 10 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕಂಪ್ಲೈನ್ಸ್ 10 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅಡ್ಮಿಷನ್ 5 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಈಗಾಗಲೇ ಪ್ರತಿ ಸಾರಿ ಬರೋದು ಟೈಮ್ ಕೇಳೋದು ಅಷ್ಟೇ ಇನ್ನೇನು ಬೇರೆ ಏನಿಲ್ಲ ನೋಡಿ. ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ on several occasions and council was absent on 14/10/22. And also wide order dated 14/10/22 made it clear that it is the appeal of the year 2018 and doesn't find any reasons to adjourn the matter. However, to afford a final opportunity, order to list the matter on 3/11/22. On 3/11/22 also, council has sought time. This same was adjourned. And again listed on 7/12/22 and 11/1/23. And on previous occasion 11/1/23 also junior council sought time. And today also council again seeks time. Hence adjourned on cost of rupees 1,000 payable at registry. ಯಾವತ್ ಬೇಕು ಹೇಳಿ ನಿಮ್ ಡೇಟೇ ಕೊಡ್ತೀನಿ. ಯಾವತ್ ಹೇಳ್ರಿ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಏನ್ರಿ? How many times court has to read the papers? Suit was decreed in respect of item of 1, 2, 3 and 6. 4 and 5 rejected. D4 claim also rejected. Modified in the appeal. ಯಾವ್ದು ಬೇಕು? 25th. This matter on 25th. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಇದು ಅಷ್ಟೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಬ್ಸೆಂಟ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ವಿ ತೋಳೆ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಂಡ್ ದಿಸ್ ಕೋರ್ಟ್ ವೈಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 9/1/23 passed an order since council was absent both in the early morning and also in the afternoon. To meet the ends of justice, one more opportunity was given to the council. And also made it clear that if the learned counsel for the appellant doesn't appear on the next date of hearing, the appeal will be dismissed for non-prosecution. In spite of the said order, no representation. And this is the appeal of the year 2021 and it appears the appellant counsel is not diligent in pursuing the matter and hence dismissed for non-prosecution. CH-13. Injunction.
The plaintiff alleges that the social property has been allotted to him, even though the certificate. The defendant, as per exhibit D1, which has been admitted by him in the cross examination. In that, he has specifically admitted that Vajana Bidskodi and Benefit. Trial court, this complaint has been given by the defendant. So the also. PW1.
PW?
PW1. Enter. ಪ್ರತಿವಾದಿಗಳು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನೇ ನನ್ನ ಜಮೀನು ಆಗಿದೆ. ಪ್ರತಿವಾದಿಗೆ ಮಂಜೂರಾದ ಜಮೀನಿನಲ್ಲಿ ನಾವು ಇಂದಿಗೂ ಸ್ವಾಧೀನತೆ ಮಂಜೂರಿನ ಪ್ರತಿವಾದಿಗಳು 2028 ಜಮೀನು ಬಹಳ ವರ್ಷ 3 ಎಕರೆ ಅದೇ ಜಮೀನು ಪ್ರತಿವಾದಿಗಳು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನು
ಯಾವ ತರ ಓದ್ತಾ ಇದೀರಿ ನೀವು? 8/12/2014.
ಪ್ರತಿವಾದಿಗಳು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನೇ ನನ್ನ ಜಮೀನು ಆಗಿದೆ.
ಪ್ರತಿವಾದಿಯು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನೇ ನನ್ನ ಜಮೀನು ಆಗಿರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗೆ ಮಂಜೂರು ಆದ ಜಮೀನಿನಲ್ಲಿ ನಾವು ಎಂದಿಗೂ ಸ್ವಾಧೀನತೆಯನ್ನು ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನನ್ನು ಬಹಳ ವರ್ಷದಿಂದ ಹೊಂದಿದ್ದು ಅವರಿಗೆ ಏನ್ರಿ ಇದು? ಡಿಪೋಷನ್ ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು, ಅವ್ರು ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? There is an admission with regard to the possession is concerned. ಪ್ರತಿವಾದಿಯು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನೇ ನನ್ನ ಜಮೀನು ಆಗಿರುತ್ತದೆ ಅಂತಿದೆ. ಅಲ್ಲಿಗೆ ಡಿಫೆಂಡೆಂಟ್ is cultivating the land. How the trial court can grant the relief of declaration? ಸರಿ, ಇಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಇದೆ, ಅವ್ರು ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದಾರೆ. ಅಡ್ಮಿಷನ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀರಿ ಅಂತ ಅಲ್ವಾ? But what is the total extent granted in favor of the plaintiff? 2 acres. Defendants ಗೆ 3 acres 10 ಗುಂಟಾಸ್. ಈ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಆಗುವಾಗ ಸ್ಕೆಚ್ ಮಾಡಿಲ್ವಾ?
2 ಸ್ಕೆಚ್ ಇದೆ.
2 acres ಗೆ ಮತ್ತೆ 3 acres 10 ಗುಂಟಾಸ್ ಸ್ಕೆಚ್ ಇರುತ್ತಲ್ಲ. ಲೀಡಿಂಗ್ ಆಯ್ತ್ರಿ. ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ಸ್ಕೆಚ್ ತಯಾರು ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ಮಾಡಿರ್ತಾರೆ. ಈಗ ಮೋರ್ ಸರ್ವೆ ನಂಬರ್ ಸಾರೆ ಬ್ಲಾಕ್ಸ್ ಮಾಡಿರ್ತಾರೆ. ಅದು ಎಲ್ಲಿದೆ ಸರ್ವೆ ಸ್ಕೆಚ್? P2 and D8. ಸೂಟ್ ಅಲ್ಲಿ ಏನ್ ಬೌಂಡ್ರೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಕ್ಸಿಬಿಟ್ P2 ಪ್ರಕಾರ ಇಲ್ವಾ? ಏನಾಯ್ತು ಕಮಿಷನ್? ಈಗ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ ಬೋರ್ಡ್ ಆಗಿಲ್ವಾ? ಇಬ್ರದ್ದು ಆಗಿಲ್ಲ. ಏನಾಗಿದೆ? ರೆಕಾರ್ಡ್ಸ್ ಆಗ್ಲಿ, ಬೋರ್ಡ್ ಆಗಿದೆ ಇಲ್ಲ? ಬಟ್ ದುರಸ್ತ್ ಮಾಡಿ ರೀ ನಂಬರ್ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ? But how you are going to identify the property? Survey number same. ಇಬ್ರಿಗೂ ಸಾಗುವಳಿ ಚೀಟ್ ಇದೆ. ಲೊಕೇಶನ್ ಎಕ್ಸಿಬಿಟ್ P2 and P8. While granting permanent injunction, property should be identified first. But also your admission that ಪ್ರತಿವಾದಿಯು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನೇ ನನ್ನ ಜಮೀನು ಆಗಿರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ದಿ ಅಡ್ಮಿಷನ್. ಪ್ರತಿವಾದಿಗೆ ಮಂಜೂರಾದ ಜಮೀನಲ್ಲಿ ಇಲ್ಲ. ಬಹಳ ವರ್ಷದಿಂದ ಸ್ವಾಧೀನಗೊಂಡಿದ್ದು ಅವರಿಗೆ 3 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಗೆ ಸರ್ವೆ ನಂಬರ್ 28ರಲ್ಲಿ ಬ್ಲಾಕ್ ನಂಬರ್ 58 ಮಂಜೂರು ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಬ್ಲಾಕ್ ನಂಬರ್ ಬೇರೆ ಇದೆಯಾ 58? ಇದು ಟೋಟಲ್ ಇದೆಯಾ ಸರ್ವೆ ನಂಬರ್ 28? ನಿಮ್ದು ಎಷ್ಟು ಬ್ಲಾಕ್ ನಂಬರ್? 28 58 28 ಬೇರೆ ಬೇರೆ ಅಲ್ಲ. Try to note that said to cross-examination made on 8/12/24, wherein the defendant has furnished Saguli chit, which is marked as Exhibit D4. On perusal of the said document, wherein it can be noticed that the said letter is issued on 29/4/2015, stating that 3 acres 10 kuntas of land is granted in favor of the defendant. That means to say that as on the date of the cross-examination, that is on 18/12/2014, no grant was made in favor of the defendant, because Exhibit D4 is a subsequent document bearing dated 29/4/2015. Further, during the cross-examination, it is suggested that ದಾವೆಯಲ್ಲಿ ಸಮೂಹಿಸಿದ ಸ್ವತ್ತು ಪ್ರತಿವಾದಿಗೆ ಸಂಬಂಧಿಸಿದ್ದಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 28ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ನೀಡಿರುವ ಸಾಗುವಳಿ ಚೀಟ್ ಪಟ್ಟಿಯನ್ನು ವಜಾ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಏನ್ರಿ ನಿಮ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಗ್ರಾಂಟ್ 29/4/2015. ಒಂದ್ ನಿಮಿಷ ಯಾರೋ ಒಬ್ರು ಹೇಳಿ. Commissioner was not appointed. What happened that application? Rejected. You are not making any claim in respect of 2 acres of land granted in favor of the plaintiff.
That's the reason why also
Exhibit D1. D1 series 7. D series. D series ಅಲ್ಲ ಮಾಡುತ್ತಿರುತ್ತಾರೆ ಇವರ ಮೇಲೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಸಲ್ಲಿಸುತ್ತಾರೆ ಮತ್ತು ಅವರಿಗೆ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿ ಆಗಿರುತ್ತದೆ. ಈ ಜಮೀನು ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಿಕೊಂಡು ಬರಲು ತಿಳುವಳಿಕೆ ಪತ್ರ ಕೊಟ್ಟಿದ್ದರು ತಮ್ಮ ಜಮೀನನ್ನು ಬಿಡಿಸಿಕೊಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಬೇಡಿಕೊಳ್ಳುತ್ತೇನೆ. ರಾತ್ರಿ ಸಮಯದಲ್ಲಿ ಹೊಲವನ್ನು ಬೇಸಾಯ ಮಾಡಿರುತ್ತಾರೆ. ರಾತ್ರಿ Who gave undertaking? ನಾವು ಮೇಲೆ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ಫಿರ್ಯಾದಿದಾರರು ಕೂಟ ಫಿರ್ಯಾದಿಯ ವಿಚಾರಣೆ ವಹಿಸಿ ತೆಗೆದುಕೊಂಡೆವು. ಫಿರ್ಯಾದಿದಾರರು ಸದರಿ ಆಸ್ತಿಯನ್ನು ನಮಗೆ ಸೇರಿದ್ದು, ಅದು ಯಾರಿಗೂ ಸಂಬಂಧವಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದು. ಸದರಿ ಜಮೀನನ್ನು ಹೋಗಿ ನಾವುಗಳು ಯಾವುದೇ ರೀತಿಯ ತೊಂದರೆಯನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನಿನ ಬಗ್ಗೆ ನಾವು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಗೆಹರಿಸಿಕೊಳ್ಳುತ್ತೇವೆ. ಇನ್ನು ಮುಂದೆ ಅದರ ತಂಟೆ ತಕರಾರಿಗೆ ಜಮೀನಿಗೆ ಹೋಗುವುದಿಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟರೆ ಯಾರು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇದೆ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಯ್ತು ನೋಡಿ ಮೇಡಮ್. But the appellant counsel and also the counsel appearing for the respondent. The respondents have approached the trial court seeking the relief of declaration and injunction. Trial court, after considering the merits, declared as plaintiff is the owner and absolute plaintiffs are the absolute owners of the social property, and also restrained the defendants from interfering with peaceful possession and enjoyment. Being agreed by the order, an appeal is filed in RA number 123 of 2020. And appellate court also on reappreciation of material available on record dismiss the appeal and confirm the judgment of the trial court. Hence, the second appeal is filed. The counsel appearing for the appellant would vehemently contend that in spite of there is an admission that defendants are in possession of the property, but also the plaintiffs themselves have given the complaint in terms of exhibit D1 and also given undertaking in terms of exhibit D2 regarding possession is concerned. Both the courts have committed an error. Adrian. I 358 is the block ಬೇರೆ ಇದೆ, but you have admitted in the cross examination. I am framing substantive question of law only with regard to the possession is concerned. ಆಯ್ತಾ? Having heard the counsel appearing for the respondent would submit that block number 28. In block number is 28. 28 is the property granted in favor of the plaintiff. And defendants claiming their property as block number 58. Both the courts have given the finding with regard to the identification of the property and declared as absolute owner. Having heard the respective counsel and also on perusal of material with regard to the possession is concerned dispute between the parties. Though it is a concurrent finding, matter requires to be admitted and a substantial question of law has to be framed. Following substantive question of law are framed. That is the judgment of decree of the trial court. And also the confirmation by the appellate court requires interferes and both the judgments are not legally sustainable. And the same is passed without considering the material on record, particularly the admission elicited, whether it amounts to perversity in giving the finding. With regard to the possession is concerned, it is the only ಇಂಜೆಕ್ಷನ್ ನಿಮ್ಗೆ ಮೇಲೆ against ಇದಾಗಿದಲ್ವಾ? The register is directed to secure the records of the appellate court and also from the lower court. The appellant is given 4 weeks time to file paper book. Meanwhile, the judgment and decree of the trial court is stayed. Shankar Shastri.
I am for the respondent number 2.
Yes, R2.
Yes.
You already sold in favor of respondent number 2?
No.
He sold the property in favor of whom?
In favor of third party is not a part. My contention is that plaintiff has proper standing to maintain an injunction against defendant since he has already lost his right of.
What about respondent number
2?
Respondent.
So the Lordship may kindly see the page number.
Page number?
Page number 57.
57.
That plan attached. Plaintiff appellant is in possession of plot number 3.
Plot number 3.
Plot number 3.
That is defendant number 2.
Yes, different number. Different number is the husband of different number.
Defendant number 1 is the husband of
Different number.
2.
So initially the entire stretch of land, plot number 1, 2, and 3 was in a common stretch. After that, the appellants have entered into an original owner.
Original owner.
Original owner. In respect of the entire property, subsequent to which a portion was allotted to first plaintiff, and a second plaintiff was also allotted plot number 2 minor. And original owner has executed sale deeds in favor of defendant number 2, plaintiff number 1, and plaintiff number 2 minor. In the meanwhile, a portion of 3/10 of land was kept as an approach road, my lords. The old question is in respect of at the entrance, the plan attached. In the recital, it is 10 feet wide road. At the entrance, when the plan was attached, there was a small deviation in respect of the entrance. Now the plaintiff number one plaintiffs are claiming that this 15 feet entrance and 10 feet entrance we have enclosed. Subsequently, what happened? The original owner executed a rectification deed in favor of different number 2, removing that ban, and then registered deed was executed. Now, the trial court, considering all these facts, dismissed the suit of plaintiffs. After that, they went in appeal, and the appellate court reversed the order of trial court. There is a clear positive findings that in the recital of the entire stretch of land where it was executed.
Whether that approach road is mentioned in the sale deed or not?
Yes, all the three sale deeds.
All the three sale deeds
Sale
are
deeds,
also
it is.
mentioned.
All the sale deeds are also mentioned 10 feet road, my lords.
10 feet.
10 feet.
Huh.
In the entrance, there is 15 feet. There is no mention according to the respective sale deed. Three sale deeds is not mentioned. Only in the plan there was a pen. Taking advantage of that mistake, what happened is that they have appellate court has reversed the trial court findings in spite of producing all the documents. Subsequently, what happened?
In all the three sale deeds, only mentioned 10 feet road.
No. At the entrance, it was 15 feet throughout, and all those sketches formed part of the sale deeds, all the sale deeds. Common vendor was Godfrey Pinto. It is only without our knowledge, this defendant number 2, he has modified after he purchased the land on the eastern side, the northern side, which your lordship will get plot number 4, property purchased by defendant number 2. Now, he wants to have this road. The trial court's finding is that it is as if it is a right of easement he has, but it is the contractual theory. All the three sale deeds formed part of the records, wherein it says 15 feet at the entrance, and this is the exclusive road to reach the plaintiff's land alone.
The sale deed, there is no mention that entrance there is 15
Is there any mention that 15 feet in the entrance?
Yes, yes. It is formed part of the sketch. The sketch itself, he has modified without. Your lordship may kindly see what he has done is he has rectified his sale deed. On the basis of
But
that,
what is the rectification?
Rectification is
rectification is the 10 feet.
Not in the recitals.
10 feet.
10 feet is at the entrance. 15 feet. It doesn't know. 10 feet. That's all. And this is and
that 15 feet is only in entrance.
Yes.
Only in entrance, not
entrance.
Road.
Not road, but according to me, the understanding is that even in all the sale deeds, that 3 cents of land reserved by the original owner to reach this plot number 1, that is exclusive right of way to reach plot number 1. This defendant number 2, he is purchasing on the northern side by virtue of his subsequent sale deed. He says he has access as if he has got a right of way to reach that after the northern. He demolishes northern wall and he wants to have access to another plot he subsequently acquired. That is how the appellate court, on appreciation of the entire material on record, found fault with the trial court that there is no, when the road is exclusively meant for the plaintiff, first plaintiff, plot number 1, the question of his exercising a right of easement to reach plot number 4 would not arise. And it's a categorical finding recorded by the first appellate court. I don't think, my lord, it is a factual, being a final court of fact, the appellate court has reversed it. And the wall that was demolished has to be restored, my lord. That is a sum and substance of the entire case. I don't think, no doubt it is a divergent findings, but ultimately the appellate court, being a final court of fact, has come to a just and reasonable conclusion. And my respectful submission to you as a respondent that there is no substantial question of law as such. That's all, my lord. Then it is between the court and the appellate, my lord. Admission, I cannot come in the way.
Yes, counsel.
All the sale deeds, my lords, in respect of plot number 1, 2, and 3, recital clearly says that the common approach road is for the benefit of all 3 plot owners, and this particular stretch of land has not been assigned to anyone. It is still retained with the owner. Second issue is that if in the recital, all the sale deeds, the extent of land is 10 feet. Nowhere is mentioned in the recital in any of the sale deeds that at the entrance there is 15 feet wide entrance, and after that there is 10 feet entrance. Commonly, it is all 10 feet entrance road. So now that one plot number 4 is purchased by different, that is applicant number 2, he has got a right of way through this way into his plot for the purpose of parking his car. This was challenged and
Plot number 4 sold by whom?
different party.
Different party.
Different parties.
How he can confirm the right in this pathway?
Yes.
Yes, Lordship.
In respect of plot number 4.
It is a common plot owners, my lord.
Common road.
Common for all the benefit of all the plot owners.
But whether the property which was plot number 4
Yes,
farmed,
yes.
whether they have provided the pathway or not?
No.
That is
No, no.
different owner it is being purchased.
While purchasing the from different persons,
Yes.
while plot number 4 was farmed, is it not their duty to provide a road for that plot number 4? Why you are using this plot road 10 feet?
This is different number 2 is using that, nobody else is using, my lord. Common pathway.
That is exclusively for the plot number 1, 2, and 3.
Yes, I am plot number 3, my lord.
No. Now, how we can access with regard to the plot number 4?
From south to north, he wants to have access. That's what that's why he demolished the compound wall.
Plot number 4 exclusively belongs to some other person.
Some other, yes, sir, admitted.
The owner, that beneficial owner is the ownership still rests with the owner, original owner, my lord. This pathway.
Pathway is in respect of plot number 1, 2, and
And
3.
it is
That is 10 feet.
10 feet.
How you can access the very same road in respect of plot number
Correct,
4?
correct. That's all. That's right, sir.
That plot number 4 belongs to different person. You have purchased the plot number 4 also.
Yes.
There must be a separate access to the plot number 4.
There is a separate-
That's why the problem started between you and the plaintiff and defendant.
Correct.
How you can access this property? This is exclusively in respect of plot number 1, 2, and 3. How you can claim the right in this pathway?
Because
If the plot number 4 also belongs to the very same vendors of plot number 1, 2, 3, then your argument can be accepted.
and after that, the city municipal corporation has taken over this particular land and they have this road. And they have developed this land and now it is being maintained by Mangalore
No.
City Corporation, my lord.
No, madam. It's a private road. That's a finding of the appellate court. Clear finding. It is not at all a public road.
I have produced all the documents from City
No, no.
Municipal Corporation.
Now there is a divergent finding
Divergent
with
finding.
regard to the accessing
As
the land.
land. So far as the other aspect, the appellate court has held is that there is a limitation period for executing a rectification. That is not correct in government. And insofar as relief granted to plaintiff number 1 who is no longer interested, cannot be granted any relief, if they relief when he is not having any interest over the property. Beyond the fact that subsequent purchases are not brought on record or they are not joined as plaintiff in this.
No, as on the date of suit, it has to be done. Now that he has sold.
During the trial itself, it has admitted by the plaintiff is that he is not having any interest over the property. He has sold that during the trial.
Who sold the property?
Plaintiff number 1 has sold the
Property in favor of whom?
different party. He is not a party to the proceedings.
Yeah.
Dependent
But then when it was sold?
during the pendency of the suit.
During the pendency of the suit.
During the pendency
In favor of whom?
favor of
Once you have sold the property, how?
I am for the plaintiff number 2, my lord. Plaintiff number 2. I am in the middle, your lordship, in the middle portion. It is now even that whatever that is sold, which acquired, right was acquired, that has been sold. So the list would continue, whether it is for him to implead, it is for him to implead and get a declaration.
Once you have sold the property, how you can seek for the relief against?
No, I am there, my lord, plaintiff number 2, as far as I am concerned.
Plaintiff number 2, plaintiff number 1 sold the property.
Yes, madam. As He is not affected. Now we played
That is in respect of plot number
1.
Plot number 1 minus.
You have sought for the relief for plot number 1 and 2 both.
No, what I am saying, I am trying to seek relief that this pathway,
Plot number 2 on second
which
page.
is now what he has done, my lord, on the northern side, your lordship sees that compound wall, it is indicated.
Counsel, you are not answering to my question. Once you have sold the property, how you can continue in this suit?
No,
The subsequent purchaser must be added as a party to the proceedings.
No, my suit is, I am plaintiff number 2, my lord. I continue to.
So you are plaintiff number 2.
Yeah, yes, my lord.
Plaintiff number 1 is not pursuing the matter.
Yes, yes.
Plaintiff number 1 is the owner of the plot number 1.
Yes. I am in the middle, plot number 2.
You are in the middle.
Second.
Plaintiff has not reduced any, plaintiff number 2 has not reduced any evidence for the fact.
But
Suit is
I am
going to be both. One of the plaintiff has been examined. Need not necessary to
Yes,
examine all the plaintiffs. All the plaintiffs.
But the question of right that whether any limitation period is set for rectification deed, because the appellate court has
rectification, we are not parties, my lord. Rectification deed, that's what the appellate court says, my lord. They are not, behind our back, he got the rectification deed, which is not binding on it.
Appellate court, what has held is that after the period of limitation, you cannot execute any rectification.
No, even rectification. Without the right accrued when it was sold.
Plaintiff number 2 after selling his rights, whether he has got any right to the matter.
Why you got the rectification deed?
Rectification to correct the defect in the
Entrance.
plan. Only in the plan.
Huh?
Only in the plan, my lord. Plan attached to the deed.
That's the original
In
plan.
plot number 3 or
Number 3, man.
plot number 3?
Plot number. The recitals, the body of the recital, all the plot. Sale deed clearly mentioned that the common pathway is for 10 feet. Now, because of this defect in that plan, plaintiff is conducting that there is entrance is 15 feet wide. So that has been rectified by the original owner, saying that correcting the plan.
What plan?
That is only the plan.
Plan
Plan attached to the
sale deed.
Sale deed.
But earlier sale deed, what was the
Plan.
When was shown.
Huh?
The page number 21, this when was shown in the plan.
How much
15 feet.
area? 15 feet. On the earlier,
It formed
that was
part of
rectified
the.
as 10 feet only, not 15.
Not
It formed part of all the 3 sale deeds, my lord, that plan. So without hearing the plaintiffs 1 and 2, he has rectified, and on that basis.
10 feet road, my lord.
So it has to be.
10 feet roads. That is not being disturbed, my lord.
But in respect of plot number 2 and 3, 1 and 2,
10 feet road only.
10 feet road only. But now he claims that no, that is 15 feet.
That is only because this defect in the plan that they are taking advantage of that.
No, my lord, it is a page, appellate court also has discussed at page 78, paragraph 52.
But while getting the rectification deed, these parties are the plaintiffs.
Not penal. Not penal.
Good. Third. Admit. The trial court dismissed the suit in OS number 329 of 2009. And the appellate court reversed the findings of the trial court and declared the suit. One second. Declared the suit. Setting aside the judgment and decree of the trial court. Consequently granted the injunction restraining the defendants by way of permanent prohibitory injunction from demolishing the northern wall of the common road at any point and oblique or installing any gate in the said wall. It also directed by way of mandatory injunction to reconstruct the demolished portion of the northern wall of the common road or restore it to the original condition within 3 months from the date of the order. And on their failure to do, the plaintiff to get it done through process of court at the cost of defendants. Having heard the respective counsel, and also in view of the divergent finding, the dispute between the parties with regard to the passage which leads to plot number 1, plot number 2, and plot number 3. On the northern side, northern side.
Yes.
On the northern side. And also on the northern side, road in all the sale deeds, pathway is mentioned to access the property of plot number 1, plot number 2, plot number 3. And hence, in view of the divergent finding of the appellate court, the following substantive question of law arises for consideration to decide the matter in second appeal. Whether the first appellate court committed an error in reversing the finding of the trial court, ignoring the material available on record. What are the substantial question of law you have framed?
That is my page number 30.
Well, ಅದು ಬರೋದಿಲ್ಲ ಅಂದೆ. That is not your defense also. Only that is the only question.
And you not maintain the status quo because the once operation it ಮಾಡಿದ್ರೆ status quo ಯಾಕಂದ್ರೆ compound wall ಹಾಕುದು gate ಹಾಕುದು all those things let it be in order of status quo to be done. Otherwise it will road will be formed from east north to south. Our ಇನ್ನೊಂದು ಇದಕ್ಕೆ ಅದಕ್ಕೋಸ್ಕರ it's better my lord, it's ends of justice.
We consider the material and record and also considering the filed by the apparent counsel to stay the judgment and decree, and when the document itself discloses that there is a pathway to the extent of 10 feet, parties are directed to maintain status quo and not to prevent the owners of the plot number 1, plot number 2, and plot number 3 to prevent ingress and egress the plot number 1, 2, and 3. Use modest.
Yes, ma'am.
The registry is directed to secure the records of lower ಬಂದಿದೆಯಲ್ಲ paper book ಹಾಕ್ಬಿಡಿ within 4 weeks the appellant is directed to file paper book. Declared as absolute owner by the trial court.
Law of traders. That's what it is. One was granted land in survey number 37.
To the extent of?
The extent of 4 acres.
4 acres.
In Marasanga with Radha Bangalore. This was Sorry, year 1965 from Muninanja part to Mariswama. Then my lords, again in 1960.
Entire extent or?
Okay. Bhajantri Muniappa on 29/10/1965. Then from Bhajantri Muniappa to
2910,
1965.
first one,
Not first two.
20. Within 3 months, property was sold. Right.
Venkatramappa in the year 1966. 1966. Subsequent to that, my lords, was acquired by N. Venkataramaya on 1969.
19.
Was the first defendant for the as purchased it 1870. During his lifetime had made a registered will. But this registered will is dated 26. But Gangappa died on 3.
Gangappa is the first defendant. First defendant.
But Gangappa died on 3.
17.
The hardships became the legatee. Became the owner of the institution. Point here is that James was
Sale deed. The grant.
records of the easy convenience.
Hello, what is their case? Plaintiff's case. 22. 1962. What is the extent? It is also 4 acres. Survey number 57. New number. 57 only. Whether his property is ported or not. Not yet ported.
His claim is 57, but finding of fact is the grant made in favor of the appellant is in survey number 55.
55. Now it is concurrent finding or?
There's the suit schedule property in survey number 57. Originally belonged to Chikkamarappa by way of grant, which is dated 23/4/1962. They themselves have produced the document.
Original grant in favor of whom?
Original grant is in favor of
Chikkamarappa.
But this will also find that exhibit
Again, any sketch while granting the land, any sketch is prepared by the revenue authority because the larger extent of 125 acres. ಆಗಿದೆ ಫಸ್ಟ್ ಆವಾಗ ಗ್ರಾಂಟ್ ಆದಾಗ.
Survey number 57 was never renumbered as survey number 84 and the authorities never changed. Survey number 57 that can be looked by the routing the RRIL as well as the RTC including the building. You have to kindly see. Their case is survey number 57, 4 acres was granted. And subsequently there have been several sailings. In while the first survey, the second survey onward, what they did was survey number 57, survey number 84 was mentioned. Subsequently, that was carried on in all the sailings. Though there was, and in the return statement by them, they specifically said that at no point of time survey number 57 was assigned survey number 84. That was the case. And in fact, I have summoned the Tahsildar who has not as paid us before, who has come and given evidence saying that 4 acres of land has been granted in my favor. And that is
quoted as 84.
Survey number 55, not survey number 55. That is the categorical finding given by both the courts. Son of page 166.
That is survey number 57 only. But in your subsequent sale deed, how you mentioned the property number as 84? Huh. 66.
But just that by reference number LNTS 550 or 6160.
In favor of Muninanjappa. Survey number 57, 4 acres.
So confirm not find this act. Various other this thing, and the same is also confirmed by the plaintiff in this cross examination. Not take up page number
240.
Okay, paragraph number 21. Fourth page. Sir, 68, 68, paragraph.
ಇಲ್ಲೇನ ನೀವು ಚಿಕ್ಕಮಾರಪ್ಪ ಅಂತೀರಿ, ಇಲ್ಲಿ ನೀವು ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇರೋದು ಮುನಿನಂಜಪ್ಪ. ಮುನಿನಂಜಪ್ಪ ಇಲ್ವಾ?
ನಮ್ಮ ತೊಂದರೆಗೆ ಅಲ್ಲ ಅನ್ವಯಿಸ್ತೀವಿ. Most of the friends they are claiming by way of the grant, which is not 69 at exhibit 1. Not that will find it at page number 60.
169 or 69?
Page 60. Exhibit 1. ಹೆಸರು ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅವತ್ತು ಅವ್ರ ತಂದೆ ಹೆಸರು ತೋರಿಸ್
69.
ಅಲ್ಲಿ the name of the father's name is not mentioned. This is a This last examination. Cross examination. Page 267. Backside 267.
260.
267. That part notes at the paragraph number 4. ಕೆಲವು ಮಂಜೂರಾತಿಗಳಲ್ಲಿ ಒಂದು
ಎಷ್ಟು ಜನರಿಗೆ
exhibit ಯಾವ document they have not produced in order to show that the land was granted in terms of money and whereas the appellant before your lordship has produced document at exhibit D2, which is the original Sagwali Chiti. Lords will find it at page number 106. Original grant
order ಎಲ್ಲಿದೆ 160
exhibit
160 166 that is exhibit D2 167 ಅಲ್ಲ ಇದೆ 23 ಇಲ್ಲಾದ ಒಂದು ಎಕ್ಸಿಬಿಟ್ D2 ಅಂತ ಇದೆ
exhibit is marked on behalf of the plaintiff. That is not laying performance. Exhibit
ಈಗ ನಾವು 123 in page number 123 exhibit P50 LNDSR ನಂಬರ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ
outline on the original grant order, SR 550 of 6162, which is at page number 166, and at page number 167, very specifically, what the survey number as well as the estimate document is mentioned. Now, 1979 on the date of execution of now 1999 ನಲ್ಲಿ ಅವರು ಕೇಸ್ ಆಗಿದೆ. Again 2012 ನಲ್ಲಿ they make a amendment to their claim seeking declaration.
Other appeal ಏನು?
That's ಇನ್ನೊಂದು appeal is as against the claim which was filed by the appellant. There were two cases. 20 case.
ಆ ಸೂಟ್ ಏನಾಯ್ತು? Common judgment by the trial court. Suit filed by them was decreed and your suit was dismissal also confirmed in the appeal. Decree of dismissal is confirmed. Sale deed, I held that sale not binding on. Subsequently.
Because in next 3 years we're gonna have one. Even assuming the fact that 1999 they came to know that there was a single issue. Within 3 years that was
ಅದು ಕೊಡಿ ಮೇಡಮ್ ಇನ್ನೊಂದು. ಹೇಳಿ. ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್ ಅಲ್ಲ ಇದೆಯಾ? ಹಾ. ಯಾವ್ದ್ರಲ್ಲಿ 1855 ಅಲ್ಲ ಅಥವಾ ಇನ್ನೊಂದ್ರಲ್ಲ 1822 ನಲ್ಲಿ 1822 ನಲ್ಲಿ 14. While answering issue number 1 regarding non-mention of father's name.
And by comparing the countries of P1 with the original register here that on 22/4/1962 the grant was made in the name of William Jaffa and therefore the authenticity of P1 is proved by plaintiff. Regarding non-mention of father's name of the grantee, the PWA has said that the father's name of the other grantees was also not mentioned in the original Darkas register. And therefore, the said omission of non-mention of the father's name of the grantee is not fatal to the case of the plaintiff. If it is true that the father's name was not mentioned, it is argued the other father was names were mentioned in the argued then only the court can suspect the genuineness of P1. Therefore, on the basis of P1, P63, and by the evidence of PWA, the plaintiff has proved that the grant of 757 was made in favor of his father. The much between see, my learned friend was referring to 7 sale deeds. By virtue of those sale deeds,
change of hands.
last purchaser, he goes before the Tahsildar, on the basis 84 hogi, on the basis of sale deed, he can see the other change, which was in the name of the other plaintiff, he gets the other change to his name. I go to the assistant commissioner, building that, you are going to your rights on that. So, if at all there were to be a grant, as conducted by my learned friend, there should have been Khata and mutation and revenue entry right from the year 1969. Most such things were before.
Not 69, 62. Before changing Kata in his favor, whether notice was given to you?
This take up 213. Now we have what it?
200 and
What has exhibit 80. Specific ಆಗಿ ಗಂಗಪ್ಪ ಅವರ ಲಾಸ್ಟ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ವೇರಿಯಸ್ ನೇಮ್ಸ್ ಇದು ಚೇಂಜ್ ಆಗಿರೋದು ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 4 acres. So various parties names ಯಾರಿಂದ ಚೇಂಜ್
ಇಲ್ಲಿ ಎರರ್ ಇಂದ ಆಯ್ತು ಅದೆಲ್ಲ ಎಂಟ್ರಿ ಇದೆ.
ಗಂಗಪ್ಪ ನೆಕ್ಸ್ಟ್ but this is a record of rates. ಅದರಲ್ಲೂ ಗಂಗಪ್ಪ name it is reflected with respect to survey number 57 to the extent of these are all documents which are marked before the
ಆಯ್ತು RR 421 ಅಂತಿದೆ ಯಾವ ಇಯರ್ ಚೇಂಜ್ ಆಗಿತ್ತು ಎಲ್ಲ
98 previous page index of lands specific
ಆಯ್ತು ಅಡ್ಮಿಟ್ ಮಾಡಿ ಸಬ್ಸ್ಟ್ರಾಕ್ಟಿವ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಫ್ರೇಮ್ ಮಾಡಿ ಡಿಸೈಡ್ 1822 or the both the council. Identity of the property, that is main only. The identity of the property irodu. But his grant is in respect of survey number 57 only. ಹೇಳ್ತಾರಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಪೇಜ್ ನಂಬರ್ 167 ಅಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ವಿಚ್ ವಾಸ್ ಸರ್ವೆ ನಂಬರ್ 50 ಈಗ ಅದಕ್ಕೋಸ್ಕರ ಐಡೆಂಟಿಟಿ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ದಿ ಪಾರ್ಟೀಸ್ ನಾವು 84 ಈ ನಂಬರ್ ಆದಾಗ ವೆದರ್ ಇಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ ಹಿ ಹ್ಯಾಸ್ ಟು ನಿಂತ ಆಗಿದೆ ಕೊಟ್ಟಿದಾರ ಪೇಜ್ 111 ಅದೇ ಕೋಡ್ ಆದಾಗ ನಿಮಗೆ ನ್ಯೂ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ದಟ್ ಇಸ್ 84 ಅಂತ ಹೌದಾ ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ 84 ಆದ ರೀ ನಂಬರ್ ಆದಾಗ ಆಗಿದ್ದಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಇದೆ ರೀ ನಿಮ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ರಿ ನೀವು ರಿಲೀಫ್ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಕೇಳಿದ್ರಿ 57 ಆಮೇಲೆ ಕ್ಲೈಂಟ್ ಕಾಪಿ ಇದೆಯಾ ಒಂದ್ ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ನೋಡ್ರಿ ನಿಮ್ ಸೂಟ್ ನಂಬರ್ ಏನು ಗಂಗಪ್ಪ 625 ಹಾ ಸರ್ 57 ಮಾತ್ರ ಇದಾವ್ರು 84 84 ಇಲ್ಲ ನಿಮ್ಮ ಇದರಲ್ಲಿ ನೋಡಿ ಡಿಗ್ರಿ ಕಾಪ್ ಇಲ್ಲಿ ಬರೀ 57 ಅಂತಿದೆ. ಜಾಲ ಹೋಬಳಿ ಬೆಂಗಳೂರು ನಾರ್ತ್ ತಾಲೂಕ್ ಬೆಂಗಳೂರು ಅರ್ಬನ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬೌಂಡೆಡ್ ಆನ್ ಫಾರೆಸ್ಟ್ ಅಂಡ್ ರೋಡ್ 57 ಇದೆಯಲ್ಲ ನಿಮ್ ಡಿಗ್ರಿ ಕಾಪಿ ನೋಡಿ. ಯು ಗೋ ಟು ಪೇಜ್ ನಂಬರ್ 101 in RSA 1855. $624 ಮಾತ್ರ ಅವ್ರ ಕ್ಲೈಮ್ ಸರ್ವೆ ನಂಬರ್ 84 ಅಂತ. ನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 84. ದಟ್ ಈಸ್ ದೇರ್ ಕ್ಲೈಮ್. ನಿಮ್ ಲ್ಯಾಂಡ್ ಫೋರ್ಡ್ ಆದ ಬಗ್ಗೆ ಹೇಳಿದೆ ರೀ ದಾಖಲೆ. ಆಯ್ತ್ರಿ, ಎಲ್ಲಿದೆ ಅಂದೆ ನ್ಯೂ ನಂಬರ್ ಅಸೈನ್ ಮಾಡಿದ್ಕೆ ನೀವೇನ ನಾವು ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ರೈಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ನ್ಯೂ ನಂಬರ್ 84 ಆಲ್ಸೋ. ವಾಟ್ ಈಸ್ ದ ಬೇಸಿಸ್? ದೇವನಹಳ್ಳಿನಾ ನೋಡಿ, ದಟ್ ಇಸ್ ಬೆಟರ್. ಇಷ್ಟೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇರುವಾಗ ದಿ ರಿಜಿಸ್ಟ್ರಿ is directed to secure the records of the trial court and also the first appellate court and list this matter for admission along with the records on. So ಇಲ್ಲೇ ದೇವನಹಳ್ಳಿ ಇದ್ದಂಗಿದೆ. 20 days ಮ್ಯಾಕ್ ಕೊಡು. ಏನ್ ಸ್ಟೇಟಸ್ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ನೋಡೋಣ. ಯಾವಾಗ ಮೇಡಮ್? 13, 14, 13 2. ಎಸ್ ನಾಗರಾಜ್. ಇದು ಈ ನೋಟ್ಸ್ ಒಳಗೆ ಈ ನೋಟ್ಸ್ ಇಡಿ ಮೇಡಮ್, ಸುಮಾರು ಇದೆ. ಚೇಂಜ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್. ರಾಜೇಶ್ ಫಾರ್ R1 and R3 R4. ಯಾವಾಗ? 17th. You are appearing for whom? R1, 3 and 5. What's your good name? ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದಾರಲ್ಲ, ಎ ರಾಜೇಶ್ ಅಂತ ಇದೆ. ನೀವೇನಾ ಅಥವಾ ಬೇರೆಯವರ? ಮೇಡಮ್ ತಪ್ಪಾಗಿಲ್ಲ. ಕೌನ್ಸಿಲ್ ಪೇಪರ್ ಬುಕ್ಸ್ ಅಲ್ವಾ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರ, ಅವ್ರು ಫರ್ನಿಶ್ ಮಾಡಿದಾರಲ್ಲ, ಗೋ ಅಂಡ್ ಕಲೆಕ್ಟ್. ದಿ ಕೌನ್ಸಿಲ್ ಸಿ ಶಂಕರ್ ರೆಡ್ಡಿ submits that he has filed wakalat on behalf of R1 and R3 to 5. Correct? R3 to 5 with NOC. Oda with NOC na? Right, Rajesh or Joten along with him. Then you argue the matter. You know, final hearing ideyalla, argument ಮಾಡಿ. ಮತ್ತೆ counsel C Shankar Reddy counsel submits that he has filed wakalat to R1 and R3 to 5 along with counsel Sri A Rajesh and on 17/1/2023. And hence office is directed to put up the same and show the name of the counsel Sri Shankar Reddy also along with A Rajesh. The respondent counsel seeks time. List this matter. Yavaga? Last occasion also no nodi, and last occasion ಏನು ವಕಾಲತ್ ಹಾಕ್ತೀವಿ ಅಂತ. ಏನಂತಿದೆ ಮೇಡಮ್? ಅಷ್ಟೇನಾ ಇರೋದು? The counsel appearing for the respondent also would submit that not yet collected the paper book and hence directed to collect the same forthwith and not to seek any further adjournment in the next date of hearing. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಇಬ್ರು ನೋಡ್ರಿ ಮೇಡಮ್. ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ, ಈ ವೀಕ್ ಇಲ್ಲ, ಈ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಇಲ್ಲ. ಏನಿದ್ರು 1ನೇ ತಾರೀಕು ಮೇಲೆ 6/2 39 ಗಂಗಾಧರಪ್ಪ ಇವಿ PN Harish for R1 Auto Sarud R3 Third, only P and Harish, third. Other side, last time, last time, Harish, P and Harish, ನಮ್ಮದೇ ಬಂದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನೀವು ಅಬ್ಸೆಂಟ್ ಅಂತ ಏನೋ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಡೇಟ್ ಹೋಗಿತ್ತು. ಕೌನ್ಸಿಲ್ ಪಿ ಎನ್ ಹರೀಶ್ ಇದ್ದಾರೆ ಅಂದ್ರಲ್ರಿ, ಇದ್ರ ಕೇಳ್ಕೊಂಡು ಹೋದ್ರ ಏನಂತ ರೀಚ್ ಆಗುತ್ತಾ ಇಲ್ಲ ಅಂತ? ಕಮೆಂಟ್ಸ್ ಮಾಡ್ತೀರಾ ನೀವು? ಆಯ್ತು ಹೇಳಿ. ಇದು ಕೊಡಿ ಮೇಡಮ್, ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಕೊಡಿ. ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಪೀಲ್. Eight of 2007. What happened, suit? Dismissed. Reversed. Reversed in appeal. What is the relief sought in the suit?
Number 113. 994/994 1537/113. In ward number 1, Bahadur Shanti Nagar. Okay. But plaintiff claims that he have purchased this site. Defendant number 3 under registered sale dated 9/11/1995.
9/11/1995.
Or attorney. Invoice number 23 of 2005. That's going to be dismissed. 2/22/4/2000. Not in so the appellate court will go in the appeal. Granted that for possession, delivery possession. It has not been cut. It is turned to the operative portion of the art part of the appellate court at page
398.
Judgment and decree passed by the custodial dated 1/3/2012 is hereby certified. Consequently, the suit of the plaintiff is declared discharged. It is hereby declared that the plaintiff is the absolute owner and in possession of the suitable property. Further, it is declared that this LD dated 16/8/1986 executed by second defendant in favor of first defendant is null and void. Defendants, their wealth agents, representatives are hereby permanently assigned for the who should property. The decree that has been passed by the appellate. I stand corrected. Unless OS number 23 of 2005 is set aside by the competent dismissal, either by way of appeal or otherwise. That decree OS 23 of 2005 is binding on the bench. And that has not been set aside. As far as the first
Whether they have filed any appeal against the judgment and decree in OS number 23 of 05? No.
No. Permission of the judgment and decree passed in OS 23 of 2005. So, I have purchased property from defendant number 2, admittedly he was the owner. Under registered sale deed, dated
16/8/1996. 1996.
Now the point for consideration before the court is whether the plaintiff has derived title to the by virtue of the alleged sale date dated 9/11/1995. Necessarily, it follows that the plaintiff will have to establish that defendant number 3 had the right to execute the sale deed for and on behalf of defendant number 2.
Whether defendant number 2 disputed the power of attorney executed in favor of defendant number 3.
Specific contention that it is post. So except plaintiff and defendant number 3, the person who stated to have executed the sale deed, no other person has been examined to establish that defendant number 2 has in fact executed the power of attorney in favor of defendant number 3.
Whether power of attorney is marked?
Power of attorney is marked.
Exhibit.
Exhibit 2 at page 75.
P2.
Page 75. Now, defendant number 2 specifically stated before the court by filing the return statement. And defendant number 3 did not file the return statement in spite of service of. He remained ex parte. But at a later stage, he comes before the court and gives evidence to say that defendant number 2 has in fact executed the power of attorney in my favor. And in pursuance thereto, I have sold the property in favor of the client. Please see the return statement filed by defendant number 2. Page 18.
17. Hmm. Hmm.
Property. And the claim was purchased from the vendor and registered credit put in 1990 consideration of 3,000. But it is found and incorrect to say that this defendant has executed a registered work on 5990 by favor of PR Mallikarjuna. There is a third defendant or false, and if there is any document referred, so he is concocted and bogus document. In fact, this defendant has not executed any sort of document in favor of the third defendant, much as the alleged level for party. So this is the specific stand that has been taken by him, and he has also been examined before the court. He has given evidence. He has denied specifically. Is DW2 Ramesh. No. Evidence of PW1 and PW2, that is the John of Target, who claims to be the John of Target. PW2, after the evidence of these persons and examination of one more witness by the Radhakrishna, PW3, a so-called document has been produced at Exhibit P17 to show that, as a matter of fact, consideration has been passed from defendant number 2 in favor of defendant number 3 in favor. No reasons are given as to why the document was not produced at the appropriate stage. Why otherwise this document can be used after the closure of the evidence of the and in the light of the denial, specific denial, no attempt has been made to exhibit P17. The trial court has dismissed the suit on the ground that no consideration is passed. You are assuming that defendant number 2 has executed a job or having defendant number 3. No consideration is passed. And the plaintiff, this defendant number 2 has not received any consideration either from plaintiff or from defendant number 3. Therefore, there is no plaintiff at all. It can be said to be executed, conferring right on plaintiff. Defendant number 2 in his written statement has specifically stated that he has sold the property in favor of defendant number 2. And to that effect, he has also been examined as with PW. As far as the execution of a document indeed by defendant number 3 in favor of plaintiff has been examined as PW1. She does not know anything about the transaction, whether any consideration is paid on the document. Who are all the persons who attested the document, where the document was executed, what are the stamp papers which have been used for the purpose of execution of the document, and who was the trial and all that. She does not know anything except saying that everything is within the knowledge of my husband. That husband has not been examined in this case. Other receipts related to this property. The exhibit P6 and P7 stand in the name of defendant number 2, Ramesh. Further, that he had no acquaintance defendant number 2 prior to the so-called attorney. And thereafter also there is no acquaintance and they did not meet each other. In fact, under the so-called power of attorney, the condition is that the fair consideration with the property is sold. It has to be transferred to the owner, that is defendant number 2. But there is no evidence to show, except exhibit P17, which has not been proved, to show that as a matter of fact, consideration has been passed under the document of sale. The appellate court proceeds on the basis that the document of sale in terms of plaintiff is of the year 1995. That is the first sale deed executed by the power of attorney holder of defendant number 2. Therefore, it will have precedence compared to the document under which defendant number 1 has purchased. Final consideration before the final. And then proof of execution of the power of attorney by defendant number 2 in favor of defendant number 3. In the absence of proof of execution of the power of attorney by defendant number 2 in favor of defendant number 3, defendant number 3 could not have executed the sale deed in favor of defendant. This aspect of the matter has not been proved by examining any testing witness. And in fact, PW3, that is Radhakrishna Karaba, he said that I have not seen the execution of this power of attorney. And plaintiff says that since defendant number 3 stated that it is the power of attorney executed by defendant number 2, I believe that it is the power of attorney executed. So plaintiff does not say anything about the execution of the power of attorney, or no evidence have been examined to establish the execution of the power of attorney. If the execution of the power of attorney is not being proved before the court, necessarily follows that defendant number 2 continues to be the owner of the property, which is not in dispute at all. He was in possession and enjoyment of the site, and he has not executed any document anymore. On the other hand, he has stated in his written statement and given evidence before the court that he has executed in favor of defendant number 1 for consideration of 1 lakh and delivered possession of. No, plaintiff did not pursue. Proceedings initiated in OS number 23 of 2005 after the dismissal of the. When plaintiff is proved to be not in possession of the property, the reason of the judgment and decree passed in OS 23 of 2005. The lower appellate court in the present appeal is not correct in holding that the plaintiff continued to be in possession of the property. Because there is any other evidence to establish that, as a matter of fact, the plaintiff took possession of the property. And when the judgment and decree passed in OS 23 of 2005 has been included. The plaintiff is not in possession of the property. There cannot be a degree of injunction. And the relief that would have been sought by the plaintiff for delivery of possession of the property. If the plaintiff is able to prove that he has indeed purchased the property under the valid credit and there has been disposal. No document or no evidence is produced to show as to when plaintiff was disposal of the property. And the PWT specifically says it is evidence that plaintiff, defendant number 1 is in possession and enjoyment of. Defendant number 2 also says that in person such as said, I have delivered possession of the property to defendant number 1. Ignoring all these aspects of the matter, the appellate court has passed the judgment and decree which has been agreed before the Parliament. The decision of the appellate court found third to the judgment of the appellate court at page 307. At page 356.
Point number 2.
Number 2. Page 374. These points are taken up together for consideration as they are interlinked with each other and to avoid the repetition of facts. Dependent number 2 of the original property. The dispute is that whether number 3 is another part of the then after referring to as GPA holder of dependent number 2 for entitled to execute the treaty on the treaty. The case is basically that dependent number 2 is executed business treaty in our favor when a GPA holder number 2. It is specific case that the GPA holder of dependent number 2 had executed a registered claim in dated 9/10/1995 for a target consideration with 1,04,000 and delivered property with control absolute right to claim. At the time of execution, the registered claim has delivered at date. The document is dated. Original registered dated 4/1993, which has been executed in the second. The original registered dated typically award is applied. That says the social property is not transferred in her name. Data related to her name and being paid in fact. In order to substantiate the claim, he herself got example as PW1 and she has paid and he has reiterated paid or miss. In her cross examination, she stated after due verification of the entries, original documents, she has purchased social property. Treated an ignorance in respect of decisions made by the first defendant that whether third defendant has paid the consideration amount as contemplated in Exhibit P2. She has stated that she has paid the entire consideration amount on the date of registration. The defendant number 2 has denied his signature on Exhibit P2 Again, the counsel for defendant number 2 cross-examined PW1, wherein he has admitted that she has got registered social property to defendant number 3, and it is not by defendant number 2. She has stated that exhibit 17 has been handed over by defendant number 3 when she met with the court complex in the earlier date of hearing. They had identified the signature of the witness on exhibit 17. Defendant number 3 examined as PW2. He has supported the case of the plaintiff and has stated that defendant number 2 had examined the registered CPA dated 14/9/1995 to sell the social property. He has stated that in husband of the plaintiff was a friend of him. He was intended to buy it, sold the property to plaintiff besides the sold on behalf of second defendant. Just after the man, I submit for something on the record show that either as on the date of the plaintiff, there has been any evidence to show that this consideration has been paid. He has stated that on the same day, the plaintiff put in possession of the social property. He has further stated that he has paid entire consideration to in the presence of one Karnataka, with PW3, and had obtained the receipt for him. He has stated that in the cross examination, the time of executing CPA, defendant number 2 agreed to the for the 1,68,000. That consideration agreed between defendant number 2 and defendant number 3, 1,68,000 rupees, but there the changing in favor of plaintiff is 1,44,000. But in respect of the price of the social property, there is nothing mentioned in the GPA. He has stated that property value for purpose registration is 1,44,000. Thirdly, it is mentioned in 18. He has stated after obtaining GPA, he has paid entire amount of 1,68,000 to defendant number 2 outside the official office and obtained the receipt for the same by defendant number 2. That it was not produced when he was examining, not examining, but at a later stage, conclusion of the evidence of PW. Only at a later stage, with the permission of the court, the exhibit 17 was produced. PW3 Radhakrishna Karaba was working as a secretary to the airline employees for society. When he was in society, his social property has been allotted in favor of independent patient by the society. He further deposed that the second defendant approached him to sell the social property since he was intended and he had some difficulty. Then he introduced the second defendant to third defendant and he had executed the GPA dated 14/9/1995 to act on behalf in respect of social property, and he has stated that at the time of passing of consideration to the defendant, he was present and identified the signature on exhibit 17. In the cross-examination, nothing elicited from the mouth of this witness which would sufficient to discard or dismiss the testimony of this witness. This is not correct. Once consideration was made with the independent. On behalf of defendant number 1, as CPM would suspend and filed a written statement government, wherein he has stated that he was not in a position to travel from Shimoga. It was evidence. And he being CPM holder, stepped into the written part. He has stated that second defendant has executed the registry credit in date 1996 is the date of registration of the date. For another registration is 82,000. It was the date of registration will be person the stated that is the bona fide purchase of the candidate. He has stated that in the subsequent the year 2005, it has filed a suit against the participant in one. Both in and after the suit was in favor of the defendant. In the cross-examination, he has stated that at the time of purchase of property, he verified the entire document pertaining and he verified the encumbrance certificate in respect of original state. Defendant number 2 informed that he had not given. He has admitted that he obtained the encumbrance certificate from the year 1983 to 22/11/94. He has not produced encumbrance certificate for the period of 23/11/1995 to 1996. In the cross-examination, he has stated that 1 week prior to the registration of security, he requested the second defendant to produce original statement, which is required at that time. Second defendant has given an affidavit by stating that original statement has been lost. He admitted that at the time of registration, he did not enquire about the encumbrance. So the encumbrance certificate is produced in the date of the alleged sale in favor of the plaintiff. Subsequent encumbrance certificates, whether produced or not produced, are relevant, not relevant for the purpose. And in fact, as on the date when the plaintiff is number 1 purchase in the year 1986, he verified the encumbrance certificate, and there was no such entry regarding the sale of the site in favor of the plaintiff. By defendant number 2, number 3, or defendant number 3 in favor of the plaintiff. The careful examination of evidence is a good part. Here the transport recording in respect of the CPA are proved in the insurance between the left transit in any situation occurred in 24 then the leadership is not affected between the CPA and the transit and moving to bring out evidence without location of safety point and allowing from non my submission before the Honorable Court is, since finding of the apparent is not correct with us, he says in his cross examination, he did not see in the execution of the power of attorney, that is Radhakrishna Karava is examined as PW3, he says in his evidence, he did not see the execution or putting the signature by defendant number 2 in the power of attorney that is stated to have been executed. The story of defendant PW2 handing over this deity to the society and PW cannot be given any credit as the same is treated nor proved by the second defendant. From this it is clear that the second defendant executed registered defendant and handed over to the evidence pertaining to without consideration of the evidence, without discussion of the evidence, right away they operated to the conclusion that the second defendant executed the power of attorney in favor of defendant number 3. The opposite findings by considered rule is it is based on sound and potent evidence produced by the plaintiff and facts of the case brought to trial. In fact, in the first statement of TW1 and TW2, there is nothing stated in respect of loss of original documents executed to the society in favor of defendant number 1. In fact, plaintiff also has not stated about the documents of title being handed over to her by defendant number 3 at the time of execution of the title. There is no doubt it was the specific plea of the plaintiff that at the time of execution of exhibit 3-2, the defendant number 3 handed over all the original belongings to the true schedule property to the possession of the plaintiff and in the plaintiff government. Nothing has been stated about it. But the learned appellant judge makes out a case. When there is such a specific plea, it is incumbent upon the defendant to deny that plea in their written statement. In the absence of any such denial, the party should not be allowed to adduce any evidence at the time of trial. Defendant number 1 produced an affidavit dated 13/8/1996 said to be executed by defendant number 2 marked as exhibit 11, wherein defendant number 2 has stated that he has not original documents pertaining to social property and did not hand it over the same to anyone. Defendant number 2 denied the execution of exhibit 3-3. But defendant number 2 has denied the execution of exhibit 3-3 in favor of defendant number 3 and his signature on exhibit 3-3. On the record, have greatly observed this platform. Defendant number 2 is in the habit of putting the defense on various documents. So, without there being any feature, without there being any even a suggestion. There is not even a suggestion. He is in the habit of putting different signatures at different places. So, the better place, other place will be different. The thing is a demonstration is everything covered document, everything covered document. Where he has admitted his signature. 2 years, the cross-examination of PWD has been conducted to different dates based on 31/10/2011 to 21/11/2012, 21/1/2012. So the deposition is to be seen. Nature of the different number is different size. There is 5 letters performed. In the next state of evidence, the signature, one scroll between the last 2 letters and the naked and one can say the quality is a signature. Both are in different size. Next one is so the trial court held that further it held that transfer of rights is not true. In the event of there are 26 that the plaintiff has not ruled further it is held that in matter 35 and 30 that PWD is not a close friend of other or a relative of the second defendant who is resident of the very good property, that is their home state is situated. It is not the case of PW1 to PW3 that PW2 was unable to manage the property and yet would execute the detail in favor of PW2 so that one can presume transaction is genuine. PW2 has specifically said that the second defendant expected rupees 1,68,000 as fair consideration of the date of execution CPA, and he has paid the same under separate receipt on that day itself. Further, it is held that it does, in all probabilities, appears to be a transaction where PW2 as a purchaser has paid the full price to the vendor PW. Instead of getting a proper deed of name, got the CPA at Exhibit P2 as a mode of transfer. The direct trial judge in support of the above findings relied on the judgment of the in Suraj Jam and the industries and others reported in 2011. Unfortunately, the direct trial judge did include the review down the same judgment on the court then from the ratio laid down in the Suraj Jam's case, it is clear that a power of attorney is not an instrument of transfer in regard to right or interest in an above property. Power of attorney is a creation of an agency whereby the grantor authorizes the grantee to do the acts specified there on his behalf. The act done by the agent's binding on the grantor. The Honorable Apex Court held that the power of attorney does not have the effect of grantee. One cannot claim the right to own property and duty. After 10 of the contract term is given for the discussion on this point, Section 180 of the Indian Contract Act defines the word agent to principal. Any agent is a person employed to do any act of other or to represent another in meeting different person for whom such act is done or whom so represented is called a principal. Further, in the act, it is provided under Section 185 that on consideration, no consideration is agency. Exhibit 3.5 is 1595. Recitals of exhibit is clear that if the executed and some personal difficulty to use property, they are appointed to act on his behalf. And a 4 and 5 of this. On reading of paragraph 4, indisputably, it manifests that power of attorney holders empowered to act upon the said GPA on behalf of number 2. The empowered to register their deed and to receive the consideration of sale on behalf of number 2. Therefore, in class 5 of GPA, it made imperative on the attorney holder to obtain receipt from defendant number 2 for payment of consideration Then from the conjoint reading of class 4 and 5, it is clear that in the first instance, power of attorney holder have given full power to execute LDD in favor of third party and to receive consideration amount on behalf of the grantee. Clause number 5 in the GPA is an agreement between GPA holder and the executor. The burden is not on the plaintiff to prove that the consideration amount is paid to the dependent on the not to dependent on the dependent alone. Admitted the dependent on the admitted. Receipt of sale consideration on behalf of dependent number 2. Surprisingly, there are recorded as findings that DW2 as a purchaser and paid the full price to vendor DW2. But instead of getting a proper deed of image, not the GPA as a mode of transit, the transit committed error according. So, when there is no such procedure, either from the dependent, or it is not case that we not transfer the right of property to recover the with a clear plan of DW2, that means a power of attorney of DW2, we are executed the credit in time. It is a position of law. The intention of the party will be ascertained and the construction of a document in the absence of any credit and in any recital of the document to be read by it is. But in the there is no any different approach before that. The holders had empowered state document. Then it is dropping. It is read. Findings of the transit, a reliance on the ratio rate down included them in industry. For the state of Ireland and another, that the plaintiff has not given very tight interest or possession of real property under the registered deed dated 14/1993, executed by third defendant as GPA holder of third defendant. Second defendant is not based on correct appreciation of the position of law laid down by the Honorable Supreme Court in Suman Jam case. The alternate issue number 2, the trial judge held that expecting 17. The receipt said to be issued by defendant number 2 for receipt of consideration and insufficiently stamped and unlisted document cannot be considered as an evidence. And for that reason, the trial judge refused to rely on the document. When the trial judge has come to the conclusion that the plaintiff has established the existence of valid power of attorney and was in substance as on the date of execution of sale deed in favor of plaintiff. Apart from that, when the GPA holder admits the receipt of the sale on behalf of finding of the trial court is on the same, moreover, in case on hand, all the original documents are in the position of plaintiff. In the conduct of criminal review, they are not taken any steps to initiate any legal act. The date of plaintiff on defendant number 2 has gone adverse influence. Therefore, for the opposite reason and discussion, my answer point number 2 is now this is conclusion reached by the appellate court. So my submission before the honorable court is in the plain, the plaintiff does not say that all the documents of title related to the property was handed over. Submitted that third defendant as what is the property to plaintiff, but registered to be dated 1995 by valid communication of unlike of the delivered position of social property. To confer the absolute right the plaintiff delivered absolute right and is in office the social property. So executing the document of that is the original register dated 14/1993, which was executed in the independent vendor, and also the original general corporate attorney dated 14/10/1999, executed by the second defendant. So for attorney, not 1999. 85 of
9/11/1995.
in 1995. It is submitted that the plaintiff purchased social property it was situated within the limits of applicable money.
Continue some other. What is the error you point out? Instead of reading entire judgment, takes time.
The execution of the power. Number two is that as a matter of fact, their consideration was passed. But the document does not accept a reciter that the same consideration has been paid previous, not on the date of execution of the deed. Not before the subdivision. Show as a matter of fact, consideration has passed. That is number two. Number three, exhibit P17 was produced before the court after the completion of the evidence of the plaintiff. And no explanation before coming as to why exhibit P17 was not produced at the relevant point of time, or where the plaintiff or DW2 to produce after the completion of the evidence. These are the facts which are important.
ಯಾವಾಗ ಮೇಡಮ್ ಪಾಠ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ಇದೆಯಲ್ಲ ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಇದೆ ವಿಡಿಯೋ ಇದೆಯಾ ಯಾವ್ದಂತ ನೋಡಿ 13 ಪಾರ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಹೋಗ್ತೀರಾ ಸಿಕ್ತು ತುಂಬಾ ಆಗುತ್ತೆ ಪಾರ್ಟ್ ಎಲ್ಲ ಕಡಿಮೆ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ನೋಡಿ ಪಾರ್ಟ್ ತಗೊಳ್ಳೋಣ ಬಾಕಿದ್ದೆಲ್ಲ ಇದು ಇತ್ತು ಅಂದ್ರೆ ಮತ್ತೆ ನಾವು ನಮ್ಮ ರೋಸ್ಟರ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿ 27th ನೋಟ್ಸ್ ನೋಡಿ Partition. 40 Shivaji Rao P. Srinivasan. ಪುರಿದಿರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಶಿವಾಜಿ ರಾವ್ ಯಾರಿದಾರ ಇದ್ದೀರಿ ಯಾವಾಗ 25th ಹೆಂಗಿದೆ ಮೇಡಮ್ ಫಸ್ಟ್ ವೀಕ್ ಫೋರ್ತ್ ಅಲ್ಲ ಸಾಟರ್ಡೆ ಅದು ಥರ್ಡ್ ಆಗ್ಬೋದಾ 3rd February 41 ಹಾ ಯಾವಾಗ ಇಬ್ರು ಡೇಟ್ ಹೇಳಿ ಫಸ್ಟ್ ವೀಕ್ ಅಥವಾ ಫಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ 3rd 42 ಶ್ರೀಹರಿ 4th onwards is this matter on 6/2 interim order granted earlier is extended till then. 46 YP Gopal Gokul Ramesh Chandra third sub ಜಾಸ್ತಿ ಹಾಕಿದ್ವಿ ಅಂತಲ್ಲ 6th ಆಗ್ಬೋದಲ್ಲ 6th third is this matter on 6th R2 to R4 ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಅಪ್ಲೈಂಟ್ ಯಾರು ಅರ್ಚನಾ ಮೂರ್ತಿ ಯಾವಾಗ ಮೇಡಮ್ 6th 7th ಕೊಡ್ತೀರಾ ಮೇಡಮ್ 7/2 ಸದಾಶಿವಯ್ಯ ಗಂಗಾಧರಪ್ಪ ಯಾವಾಗ ಓನ್ಲಿ ಪಾರ್ಟಿಷನ್ 6/2 50 ಅಭಿನಯ್ ವೈಟಿ 7th ಆಗಲ್ವಾ 7/2 ಯಾರು ನವೀದ್ ಅಹಮದ್ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ ಇದು ಯಾವಾಗ ಬೇಕು 7/2 2018 ಏನ್ ಸ್ಟೇ ಮಾಡೋದು ಈಗ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ
First attempt will be stating next.
ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರಾ? ಅವ್ರಿದ್ರೆ ಮಾಡು. 7-2 ನೀವ್ಯಾರಿಗೆ ಇದು ಒಂದೇನಾ? ಹಾ ಹಾ ಇಲ್ಲ ಮತ್ತೆ ಈಗೇನ್ ಸ್ಟೇ ಮಾಡದ್ರಿ ಫೈನಲ್ ಇಯರಿಂಗ್ ಬಂದಾಗ ಏನ್ ಮಾಡಿದಾರ ಅವರು? ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಆಯ್ತು, ಏನಾದ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರೇನ್ರಿ? ಖಾತಾ ಚೇಂಜ್ ಆಗ್ಲಿ, ಇದು ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜೆಕ್ಷನ್ಸ್. ಆಯ್ತು, ಈಗ ಎವಿಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕವ್ರ ನಿಮ್? ಆಯ್ತ್ರಿ, ಈಗ ಇನ್ನು ಸರಿ ರೀ, ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲ, ಇದು ಎವಿಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕಿಲ್ಲ ಮತ್ತೆ ದಾದಾಗಿರಿ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? ಆಯ್ತು, 7-2 ನೋ 7-2 ಬನ್ನಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಹೇಳಿ. ತೊಗೊಳ್ಳಿ ಏನ್ ಮಾಡಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಇದರಲ್ಲಿ appellant in RSA 392 of 2018 is present, and appellant counsel in RSA 452 of 2019 is absent. The counsel appearing for the appellant in RSA 392 of 2018 praying this court to consider the A number 1 of 22, and the counsel appearing for the other side is absent, and hence if the other side counsel doesn't appear in the next state of hearing, IA will be considered in the next state of hearing. This is on 7-2. ಯಾವ ಇದ್ರೂ ಏನು ಅಷ್ಟೇನ ಮೇಡಮ್? 7ನೇ ತಾರೀಕು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರೀಚ್ ಆಗಿದ್ರೆ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ, ನೀವು ಬರ್ದವ್ರ ಅಯ್ಯವನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಅಂತ ಬರ್ದಿದ್ದೀನಿ. 2018 ಮ್ಯಾಟ್ರು ಈಗ ಸ್ಟೇ ಮಾಡೋದು ಇಟ್ಸ್ ನಾಟ್ ಗುಡ್ ಇನ್ ದ ಅಬ್ಸೆನ್ಸ್ ಆಫ್ ಅದರ್ ಸೈಡ್, ಬಿಕಾಸ್ ಹಿ ಹ್ಯಾಸ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಅಲ್ವಾ? ಮತ್ತೇನ್ ಮಾಡೋದು? ಅಡ್ಮಿಷನ್ ಆದಾಗ್ಲೇ ಸ್ಟೇ ಕೇಳ್ಬೇಕಿತ್ತು ನೀವು. ಆಯ್ತು, ಏನು ಏನು ಆಯ್ತಲ್ಲ, ಆಯ್ತಾ ಸಿಗ್ನೇಚರ್?